continue. So in view of this, Lords, issuing attachment, going for recovery.
I don't know
all
why they're
this-
doing it. Yes.
that
That should
should
not
drop at
play
least.
their hands.
Another notification, it is a good news for all the petitioners, Your Lordship. Another notification in the meantime has come from CBSE. In that notification for the period 17-18 and 18-19, Your Lordship, I'm examining that notification. Also, I have obtained instruction from the department. If that notification will be accepted, Your Lordship, all the cases will be disposed of and will be set aside to the assessing officer. Why, Your Lordship, in that notification circular, a modality has been fixed, Your Lordship, in that notification that the assessing officer, what happened in all these cases, since there is a difference, so it has been added. So in that circumstances, some chartered accountant certificate
You
is
said
required.
with regard to mismatch of ITC,
Exactly, and almost
supplier and the recipient.
almost in all these cases, that is the point, Your Lordship, in all the cases, because that is the only point till now decided by
May
the.
not be, may not
I
be.
will be happy if Your Lordship.
I'm examining all the cases. So far, the 17-18 and 18-19 major cases, all the cases will be disposed of at a stage, Your Lordship. I'm examining and I'll convey you.
No, they have challenged the virus itself.
So far as the virus, they may.
16 to
They may.
C.
So they'll postpone it till they actually have a negative order. When they challenge the order, they can again challenge the virus.
Your Lordship.
Your Lordship, that circular has passed on 27/12/2022.
Oh, almost more than a month ago.
Your Lordship.
And Your Lordship, another High Court has passed that 1920 will be also applicable. Probably Karnataka.
ସେଇଟା ତ ଏପର୍ଯ୍ୟନ୍ତ ହେଇନି ନା.
Your Lordship, even Karnataka High Court and another High Court has passed an order that 1920 will be also applicable. That circular will be applicable for 1920.
That is a different thing. Your Lordship. But that has to be applied because the already CBC has issued the notification.
But you will have to make a statement then.
Your Lordship, for that reason, I have sent and for instruction.
You first get the list of those cases.
Your Lordship, I am preparing. I am also taking instruction and also I am preparing.
Only
And I'll,
exclusively, that is the demand.
exactly. Your Lordship. Good.
All right.
Item number no coercive action, Lords. Yeah, that Your Lordship.
Yeah, I've already said.
My Lord, publish. Item number 51.
May I please, my lords? This is an assessment which has been completed under section 144B of the Income Tax Act, my lord, without, my lord, giving me a draft assessment, my lords.
See,
Lordships have a
Enough.
similar matter on second of.
Instruction because I'll take instruction.
Here, your lordship would see, my lords, originally
Now,
140.
Nominal senior has somehow changed, Lord. I will reply that after Lord.
Your lordship have said
Mr.
that
Rai's got enough orders, sir. I think at least in Mr. Rai's case.
this is
No,
Mr. Rai's case, which I
Now,
was
the senior has
fortunate.
been
Ah,
changed, Lord.
that's
I'll reply that later on, Lord. Lord, I'll take notice, Lord. I will reply that.
Your lordship would appreciate, my lord. Your lordships have also given handle to the department not to go and proceed afresh, my lord, in
That's
accordance
what-
with law. So let them.
Lordship, only Lordship give me protection, Lord. Or,
You protection.
Lord, I'll back.
Your lordship may, your lordships have protected the interest of the department. I'm not going scot-free, my lords. I'm still within
So
the
you want
nets.
time for instructions you can take.
Yes, Lord, I'll take instruction.
All right. We say notice, he accepts notice and seeks time for instructions till the
If you
next
Lord
day.
give
no
it that
course
he will
steps.
appear and by the new provision, then Lord.
Then let this order pass.
Yes. New provision, Lord. I don't have any objection. Now, I not.
They can proceed in accordance with law.
My lords.
Yes.
All right. You say the challenge the present petition. Notice he accepts notice. The challenge the present petition is to a reassessment order dated 27th March 2022, passed by the National Faceless Assessment Center, Delhi. Bracket opposite party number 3. Under section 147, read with section 144, capital B of the Income Tax Act 1961, bracket Act. The short ground on which the challenge has been raised is that the impugned order was not preceded by a draft assessment order, which was required to be served on the SSC under section 144, capital B of the Act.
16.
Full stop. The show cause notice preceding the reassessment order was not accompanied by such draft assessment order. Then reproduce para 4 here and 5. That's it. The petition is disposed of in their work terms. All right.
Your Lordship,
Annex 1
giving
and
Lord liberty so that we
No,
depart.
it's there.
There-
That's
it's-
para 5.
Lord, sorry, Lord.
Ah.
it's all Annex 1 and Annex 5 may be set
Yeah.
aside now.
That's all there, sir.
Because Annex 1 and Annex 1A is there. It's Annex 1 and Annex 5.
5. All right. Instead of 1A, it will be 5. All right.
Obligement.
All right.
Item number 52.
May it please, Millards.
Yes, please.
Plus the limited point involved, Millards, is certified copies of the order sheet and search warrants, Millards, are not being given.
What happened?
Yes,
Last
madam.
time we took time for instructions.
But I am filing counter today. You'll also similar matters, Jagannath, his own matter is pending.
Ah.
My lord, here the issue is not the proceeding has not yet been completed.
Correct. So why can't
And-
we give him copies then?
No,
Millards,
you're-
I have reached the second appeal stage proceedings, Millards. The investigation is not completed. I've reached the second appeal stage, Millards.
good item.
Against the
Lots.
final orders. Sorry. Against the final orders.
Second, the assessment order has been passed, thereafter an appellate order, thereafter now the second, it is pending in second appeal.
When
If I-
the material are used.
Paragraph 11, my
Those
lord, the
material are
start of the
used
review.
in the course
Sorry.
of assessment.
Sorry, Millards.
Those material which you are seeking.
No, but
Certified
is this
copy.
officer who's sworn the affidavit aware that there been beyond the show cause notice already the matter is crossed?
Lord, I don't think, my lord, he is not aware. because-
He doesn't
because
file
he
parallel
has not-
reply,
he-
sir. The
he has
whole
not
problem-
stated- Yes, my lord, he has not stated it. So, I only say that the so cause notice has been.
He should read the petition, sir. Unless a parawise reply is filed, what's the point? Just
Today
give this
morning-
back. Let him file a proper. Just don't
Yes,
let's
your
not
lord.
take this.
Kindly back, my lord.
Ah.
Because today morning he has handed over.
You say it parawise reply. With notice, he accepts notice. Then the short ground urged by Mr. Sashwat Acharya, learned counsel for the petitioner, is that the Deputy Director DGGI was not justified in refusing certified copies of the search warrant and order sheet / note sheets in the matter. Paragraph. Then you say parawise reply to the petition be filed by the respondents within 4 weeks, rejoinder if any before the next date. Then you say no coercive steps will be taken. No further steps
That-
will be taken pursuant to the impugned show cause notice.
No, Millards,
There is no, yes,
in
before
fact,
the tribunal. no.
In fact, Millards, the facts is show cause notice was issued. And Millards, the law is that show cause notice can be issued only after the investigation is complete. Show cause notice was issued, assessment order passed. Thereafter, first appellate order has been passed. Now I have filed a second appeal during pendency of the writ
But
petition.
look at your interim application. Then that it's gone beyond that. You're still asking, saying not to proceed further to enable you to file a reply.
Yes, Millards, that is not what I'm pressing. Millards.
Then
Millards,
no
only
interim order.
prayer.
Then no interim order. Just let him say.
Only prayer, Millards, 28th, the similar matter is coming, Millards, 28th.
Yeah. This is IA. You say this petition, this application is become infructuous and is disposed of. 28 September,
28th, Millards, February.
28 February. Then how can he file reply within 4 weeks?
No, I'll sign.
Okay. Reply be filed before the next date, you say. 28th, list on 28th February. All right.
Great.
Item number 53.
May I please, Lordships. Lordships, in this matter, Lordships, limited prayer, Lordships, that the self-same official who has passed the order in original and I have complied the same depositing every tax, penalty and interest, the same officer has filed the appeal, Your Lordships. Page 31 and page 32, Your Lordships.
No, but why at this stage, what should we interfere? Whatever the appellate authority will pass that order.
Your Lordships, actually, I have already deposited the entire amount of whatever they have charged in order in original, Your Lordships.
All right.
And the self-same officer had filed the appeal and I have not challenged that order. I have deposited the tax amount. And how the self-same officer will file the challenge his own order, Your Lordships.
Anyway, that whichever appellate authority will deal with all that, madam. Why should we interfere at this stage? There's no need for us to interfere.
My learned brother may take instruction on that.
Why?
No copy has been served to us.
No, but why? Why should we get into this at this stage? Whichever is the appellate authority will deal with it.
But again,
It's
second
just
round,
an appeal has been filed. No order has been passed on that.
but again I have to appear before that authority for self-same cause for which I have already deposited the entire
Point out to
amount.
the authority, they'll deal with it. You say, since only an appeal has been filed and it's yet to be heard, it will be open to the petitioner to urge all the points being raised in the present petition before the appellate authority in accordance with law. The court does not consider it necessary to interfere at this stage. The writ petition is disposed of.
Oh, bless.
Lordship, my appearance पे note.
Item 54. My lord, GST second appeal issue, I have already made the payment of 20%.
You paid 20% or 10%?
10%,
Ah,
balance 20%.
same order. 11th September. All right.
Item number 55.
May I please, Your Lordship? Your Lordship, this is a matter wherein the petitioner is challenging the illegal rejection of the representation wherein we have seek for a refund of license fee of the veterinary outstill shop which was forcibly and illegally closed down in violation of the Orissa Excise Act, my lords. My lords, what has happened in
Again, you can go to the excise commissioner against the collector's order, right?
Millers, Millers, this is a fourth round of litigation. Millers, may kindly hear to my what I want to represent. Millers, that at 28/5/2019, IIC ASCA, IIC police station ASCA illegally without the permission of the excise authorities closed down my shop only on the pretext that they wanted to investigation some of the in one of the murder cases. They want to investigate it. They raid our shop and closed down without the permission of excise authority. Thereafter, what has happened? We represented the collector. The collector thereafter inquired into the matter. There was a report under Annexure 2 which shows that Your Lordship may kindly see Annexure 2, my lords, page 21, which says point number 1 and 3 that police has violated section 26 clause 3 of the Odisha Excise Act in closing down the shop illegally, my lords. Thereafter, another inquiry was also set up by the collector wherein it was allowed that that there was no law and order situation and it was the action of the police authorities was illegal, my lords, and they allowed to operate our shop after 9 months, my lords. There was a closure for 9 months. They allowed to operate our shop in 16/3/2020, my lords. Thereafter, what has happened? They sought for the area dues that during the closure period. We paid around 29,20,837 rupees, Your Lordship. What has happened? We had represented the collector to refund only. We have deposited the amount under protest, my lords. And subsequently, we represented the collector that the amount is to be refunded as per the rule 151 of Odisha Excise Rules, my lords. My lords, may kindly have a glance. I will just place before Your Lordship a order of the last.
My lord, first of all, this is the collector's order. The writ was filed in 2020. For the first time, it is listed today after more than 2 years. The collector's order, it has to be appealed before the commissioner.
Let him argue.
Yes, ma'am.
Milords, what has happened that there was a direction by this honorable court to consider my refund application for refund, Milords, which was rejected only on the flimsy ground that there was an apprehension that there might be a law and order situation and right situation for which he rejected my representation for refund, Milords. I will also place before Your Lordship a judgment of this honorable court wherein a similar issue I have been squarely covered. Instead, I am in a better footing, Your Lordship. I'll just provide this case law, Milords. Relevant portion is para 4 and para 7, milords. May kindly have a glance. Wherein it was directed to refund the amount that has been collected.
All this the commissioner can consider, sir.
This is the fourth round of litigation. I'm before this honorable court.
Sometimes you go to the commissioner also. Every time you're coming to this court. Let's share the burden equally.
Milords.
Counsel the petitioner seeks leave to withdraw the present petition with liberty to approach the commissioner against the impugned order of the collector, rejecting the petitioner's application for refund. If such appeal is filed not later than 3rd April, accompanied by an application, contract of delay, explain the delay on account of pendency of the present petition, considered in the course of law with the commissioner. The court clarifies it is not expressed in.
Item number 56.
Madam, Your Lordship, item number 56 are rendered infructuous.
Infructuous disposed. Warrant.
Item number 57.
57 and 58 is not present.
Not pressed.
Item number 59. Sir.
Milords, on behalf of Mr. Ramesh Chandra Vera, I seek for an adjournment. He's ill, Milords.
All right. Counsel for the appellant is stated to be unwell. List on 11 September.
Grateful, Milords.
Item number 60.
My lord, on behalf of Mr. Mahanti, kindly pass over. He is on his leg.
All right.
Item 61.
In this case, there is a delay of 145 for 5 days for filing of this appeal, my lord.
COVID time.
In COVID time, like before COVID.
Ah,
Yeah, the applicant is a illiterate person, could not know the.
when he files a writ petition, it says stop being illiterate. After writ petition, no more illiteracy. You say,
Let me notice the issue, my lord, to be just for.
leave it open for some decision. You say the delay of 145 days has not been properly explained. The reasons supported are not convincing. Consequently, the court is not inclined to condone the delay. IA is dismissed. Accordingly, the writ appeal is dismissed. Nevertheless, the question of law sought to be raised is left open to consideration in some other appropriate case. Correct.
62.
Same, my lord, 62,
Same,
63,
same.
same.
All right. 63 also.
Right.
Right.
Stress admission pastor matter item 11. Item number 11.
Despite a pass over, none of is dismissed.
Item number 17.
May I please, Lord?
Similar
here,
31.
Page 16, Lord. The question of law frame, Lord. Two ground. One is, Lord, the bad debt was written off without any evidence as per section 36(1) BIA read with rule 36(2)(1) of the Act. That the assessor never produced any document. I have given the page 11, the enactment of the Lord 36(1) BIA read with 36(2) of the Act. No documentary evidence regarding existence of debt. Document evidence that the debt was taken into account income either in the previous year or earlier previous year. Documents show that a debt has been written off in the books of account. Documentary proof to show debt claim as a bad debt claim to bad debt under 36(1) BII of Incident of Business. The tribunal, Lord, if I quoted, you will also see the tribunal finding, page 13, para 8 I have quoted. We have noted that the appellant gave advance of 2 crores to Mr. So-and-so for purchase of land. The assets in business real estate, the advance was given for the purpose of land, and the same as duly reflect in the books of so-and-so. The advance given as revenue in nature and was stand partial due to some dispute. Land could not raise the name of the assessor, seller did not turn off to refund the advance. Well, there is scrap of document, how is refunded, what is the defect, nothing. Mere statement of the assessing lord, the tribunal has come to finding that in view of the Supreme Court case TREF limited 33 are considered. And another one is rule of consistency. As a first question, that the that in the books of account, something was earlier, the assessing officer has allowed the same, but later on, without any finding, the subsequent year, the IO was assessing officer reopened this issue. And the rule of constitutional tribunal is allowed based on the Supreme Court judgment. My submission would be, in this case, in this issue, my lord. My lord, every assessment here is different and rule of constitution will not apply in each and every cases because all these books of account is different and the issue has not been properly framed as earlier. That mistake cannot be continued to protect the interest of revenue. Therefore, my lord, we are relying on two judgment. We are
All these are same matters.
No. All are different.
Each is different.
Yes.
All right. So you'd say ITA 6, that is item 17.
Yes, sir.
Is a notice returnable. 11 September.
Lord, ITA number 6 it is not.
Yeah. That,
Item 18.
that dispensing with you, Alaf. All right.
Yes.
Item 18.
18, Lord. Your Lordship, this is a.
Yeah. It's only sent back, no?
Yes, only sent back.
This being an order only of remand, the court does not consider any substantial question of law arise.
No, not only remand. Your Lordship, seem Lord the question of law, Lord. The remand only, Lord, the no natural justice and violate 2 times notification issued. Your Lordship, see the order, Your Lordship.
All right, so one more hearing only has to be given. It's all right.
Your Lordship, direct to appear before the tribunal.
Yeah.
He is not
fix
the
a date.
No, tribunal is quashed, Lord.
No,
Tribunal is
sir.
quashed. Your Lordship, see. Running page 26, Lord. Was the revisional proceeding frame 265 allow the grounds raised as in the interest of appeal before?
So let's read the reasoning. Now, para 14. Let's read the reasoning.
On the perusal above finding, the tribunal will find that in the absence of proper opportunity being provided essence of revisional proceeding, the tribunal was the revisional proceeding under Scrutiny Act. In such case, we find the associate already proceeded through the Scrutiny under 43 Act so and so, and has filed the complete detail called for the AO. Almost 21 points with interlay inputs, all detailed cash deposit, cash flow statement, detailed trade in receivable, detailed purchase, consumer transport charge, finance cost, etc. The assessors filed all these details before the event called from time to time. Again, this very assessment here was selected for by the PCI.
Why can't it be sent back, sir? Because this kind of a ground saying you were not given time to produce materials shouldn't result in the whole thing being quashed.
Yes,
It should have been sent back. We'll fix a date and make time out.
Yes.
Lordships, in this present case, your Lordships, before the assessing officer, your Lordships, they ask.
Correct.
Yes.
So what you're saying is, I wanted to produce those very materials for the CIT,
Yes.
and I was not given a chance.
Yes,
That's all.
Yes.
You see, the present appeal with the revenue is directed against an order dated 21st December 2021 of the Income Tax Appellate Tribunal, Cuttack Bench, Cuttack Bracket IT80. Allowing the SSC's appeal ITA number 17/CTK/2021, whereby the SSC had challenged an order dated 1st March 2021 passed by the Principal Commissioner of Income Tax -1 Bhubaneswar bracket PRCIT bracket, initiating proceedings under section 263 of the Income Tax Act 1961 bracket Act. Paragraph. You say, admit the following question is framed for consideration. Was the IT80 justified in quashing the impugned order of the PRCIT on the grounds of violation of national justice without reviving the proceedings before the principal CIT for compliance with that requirement? Question mark. Paragraph. The perusal of the impugned order of the IT80 revealed that the ground that made with the IT80 to quash the order of the PRCIT was that sufficient opportunity had not been granted to the SSC to place details to support the original assessment order of the assessing officer bracket AO. Paragraph. It is seen that the IT80 did not consider it appropriate while setting aside the order of the principal CIT to revive the proceedings before the principal CIT to provide such opportunity to the SSC. Full stop. That should have been the appropriate course to follow, since all that the SSC was seeking at that stage was for further time to produce the relevant documents and materials. Paragraph. In that way of the matter, the impugned order of the IT-80 is interfered with to the extent that while the order dated 1st March 2021 of the PRCIT under Section 263 of the Act will remain set aside, the matter will revive before the principal CIT. That is the matter, that is the revisional proceedings will under Section 263 of the Act will revive before the principal CIT and will be listed there on 10th April 2023. Full stop. On that date, the respondent SSC will appear and produce all the relevant documents or materials that the SSC was seeking time for. And the principal CIT will then proceed in accordance with law and pass a fresh order within a period of 2 months thereafter. The court clarifies it has not expressed any view on the merits. Full stop. The appeal, the question of law is answered in the above terms. The appeal is disposed of.
Item number 19.
19, your lordship. Frame the question, your lordship, see the
Same. Full stop. Alternative view. 263.
question page 24.
Yes.
Whether on the fact the tribunal is like a right in law in quashing the improvisation order by quoting that the principal CIT has taken a view in the matter and there is only an alternative view while there is no such view taken by the revisional authority. Your lordship, see the running page, the order of the 263 last page, 49. May I please?
Yes.
The above submission from the SSC has been carefully examined. It observed that broadly the following claims are made to be considered relying on no number of decisions from the Honorable Supreme Court, High Court, and Appellate Tribunal. The SSC has acquired a right in the property on execution of agreement for sale and payment of 90% of the agreed cost of the property to the promoter as advance. The right in property is a capital assess as per Section 214 of the Act. The relinquishment of the right in the property and diminution of the right back to the promoter in lieu of payment made by the promoter also transfer as per Section 247 of the Act. A capital asset is transferred, thus it may be a capital gain oblique loss. No capital gain or loss claimed since cancellation of deed was not present in laws for registered till end of financial year 31/3/2013. The proceeding 263 Act is not to be invoked since precondition of the initiation are not applicable in this case. It can be presumed that the AO's formed an opinion after complete inquiry and examination the assessment or does not reflect AO's opinion. Formation opinion can only be established through expression of opinion. In view of the things, I am of the considered opinion the assessment here is erroneous in so far as prejudice interest of
This is just repeating the statute. That's it.
Yes, Lord, yes, because Lordship has so many cases.
Careless, sir.
And Lord, what he has done, he has written back to the AO. And Lord, we are relying on true judgment that it can be written. Your Lordship know the section itself says it can be, if I'm place again the section 263.
So the reasons can't be just the repetition of the section, sir.
No, but he has carefully made examine.
No.
And in the order itself, your Lordship, see.
Yeah. Yeah.
The before page, your Lordship, see the A was not given any finding on that issues, not. And therefore, Lord, the.
No. This is an appeal by the revenue against an imputed order dated 23/12/2021 of the IT-80 conduct bench, allowing the SSC's appeal ITA number 178/CTK/2018, which is directed against an order dated 29 March 2018, passed by the principal CIT-1 under Section 263 of the Income Tax Act 1961 Bracket Act for the assessment year 2013-14. Paragraph. Having heard learned counsel for the department and having perused the aforementioned order of the principal CIT as well as the order of the IT-80, the court is of the view that the ITAT did not commit any error in setting aside the order of the principal CIT, which, as the court views it, simply repeated the language of Section 263 of the IT Act regarding the original assessment order being erroneous and prejudicial to the interests of the revenue without actually giving the reasons for such conclusion. Full stop. Consequently, no substantial question of law arises for consideration. The appeal is dismissed.
Item 20.
My lord, 20 your lordship, here is a case, my lord, if annexure 20 your lordship see, it is totally a rehearing of the matter. New fact, new law has been considered while passing the my lord order under section 254(2). My lord, see, my lord, whether word 47 is applicable, there is no clerical mistake not happened in the face of record. Here, my lord, clearly rehearing the matter, your lordship, see the order itself. My lord, and start from Indian Press 3023.
Only a recall, sir. They hear anyway hearing it all afresh. It's only a recall.
No, it is not 252 or petition has been considered by tribunal after passing the order of the original order of the
Correct.
tribunal.
They will again hear it, sir.
No,
They're only recalling the earlier order dated 18/1/2021 so as to adjudicate all the issues afresh.
yes, my lord, that cannot be,
Also,
my lord.
it's all right.
If you lordship see the language of 254,
Yes.
my lord, it can you only in the apparent face, mistake on the apparent face of record, your lordship.
Correct.
And here, my lord,
All
he has-
this
he
we
has
should start
got all
interfering,
these
sir.
issues, my lord.
It's all right.
And
You say the impugned order allows an application under section 254(2) of the Income Tax Act 1961, recalling the earlier order dated 18 January 2021 of the ITAT and directing fresh hearing of ITA number 366/CTK/2019 filed by the SEC for assessment year 2007-8. Paragraph having heard the receiving standing counsel for the department and having perused the impugned order of the ITAT, the court question of law arising from the impugned order, which requires to be determined by this court. Full stop. The ITAT has given sufficient reasons why it thought necessary to recall its earlier order. Full stop. Since in any event the appeal is going to be heard afresh, the court does not consider it necessary to interfere. The appeal is accordingly dismissed.
21.
21 or 19 was delay.
91 days.
19, 19. Not the
delay control.
The question is not all these similar all these matters from start from 2831 all are same Lord, group of assessing Lord. Here Lord, the claim of exemption under section 1038 after sale person tax is paid by the person to disclose before the survey team when the claim is made in a reverse statement before the year without filing the valid revised return. Whether tribunal justified to allow the exemption under section 1038. Your lordship, may I place 1038 first note, then I'll go to the 38 million.
Any income.
Any income raising from a transfer of a long-term capital asset.
1.157.
1.151.
Here it's 157.
Any income raising from transfer of a long-term capital asset being a equitable share in a company or a unit of an equity-oriented funds. The transfer of surplus A, transfer of sale of such equity share or unit in enter into an date on which Chapter 3I Finance Act 2 come into force and such transaction chargeable to security transaction tax under the chapter, provided that income by way of long-term capital gain of a company shall taken into account company books profit and income payable under section 115J. Provided also that nothing contained subclause 1 shall be applied to a transaction undertaken as recognized stock exchange located in international financial service center and where the consider such transactions paid or payable in a foreign currency. Provided also that nothing contains clause shall apply to any income raising from the transfer of long-term capital asset being an equity share in a company if the transaction of acquisition other than the acquisition notified by the central government in his behalf, such equity share is entered into after first day after 24 October 2004, and such transaction is not chargeable to security transaction at under so. Provided nothing contained in the clause shall apply to any income charging from transfer of long-term capital asset being an equity share in a company or a unity and equity-oriented fund or unity business trust made on or after first step. The purpose of this clause, equity and fund, so and so, so on. Here, my lord, your lordship, see the order of the tribunal.
Concurrent findings, sir. They've agreed with the CITA.
Yes, Lord, that concurrent finding, but Lord, if your lordship see I have relying on the true judgment of this honorable court, my lord. I have quoted that turning page 10, the judgment of the honorable Supreme Court, my lord, para 7. Here, my lord, the tribunal finding is that the person who has purchased no cross-examination has been allowed to them. But in the assessment proceeding also, he has not claimed for any cross-examination. And this court said, Lord, in the High Court said that the order has been ground and no opposition cross-examination is there. Lord, he has not asked for even. Lord.
It doesn't have to, sir.
And
it's adverse to him, it has to be provided.
And Lord, the question, Lord, the section 38 in this issue, Lord, has never been considered in any other case.
Factual, sir. It's factual. You see, these appeals by the revenue arise from an order dated 21st, common order dated 21st December 2021, passed by the ITAT, Cuttack Bench, Cuttack. It
is amount to a penny stock transaction, Lord, I can say. If your lordship, this transaction is totally not transaction. One time he has accepted and paid the tax, and subsequently is non-filing a river file a statement, they're claiming the execution. Once he has accepted in the search proceeding, he has paid the tax and admitted no exemption is claimed. Thereafter, they're filing a reverse statement, he claimed that the exemption. That is what will stand as the revenue. Can it shifted one and another in each and every stage?
All right. Dismissing the revenues appeals, ITA number 42 to 50, public CTK public 2020, against the corresponding orders of the Commissioner of Income Tax Appeals, bracket CITA, for the assessment years 2014-15 and 15-16. Paragraph. The questions ought to be urged by the Revenue Department in these appeals. Was whether after participating in after making certain statements in the survey, the SSC could, and not claiming exemption under section 10 bracket 38 of the Income Tax Act 1961 at the stage of the assessment proceedings, could the SSC turn around and claim such, and make such claim of wanting to cross-examine persons making adverse statements against SSC at the stage of the appeal before the ITAT? Question mark. Paragraph. The impugned order of the ITAT has sufficiently dealt with the factual details concerning the respondent SSCs. Full stop. The question was regarding the claim of long-term capital gains on shares in terms of section 10 bracket 38 of the Act. Full stop. During the course of scrutiny assessment, a revised computation was filed by the SSC claiming the above exemption. Full stop. After the AO rejected the plea, the SSC went before the CIT bracket A. Full stop. The CIT A was satisfied that the purchase of equity shares had been made through account payee checks, and the shares themselves were held in demat account for more than 12 months and then sold through the recognized stock exchange after payment of security transaction act tax. Full stop. A reference is made to the CBDT circular, which debarred the revenue from obtaining admissions oblique statements during the course of survey. Full stop. The SSC, the ITAT also noted the settled position in law that if an SSC had wrongly offered an item of income or omitted to make a claim of deduction in the return, he was entitled to correct such a mistake by making a request to the AO to that effect. Full stop. Another ground on which the ITAT found fault with the additions made by the AO were that reliance was placed on statement of single quote so-called entry operators unquote to justify the additions under sections 68 and 69 of the Act. Full stop. These statements were recorded on various dates in some other proceedings not connected with the SSC. Full stop. Therefore, these and further, the statements were recorded much before the date of survey conducted on the SSC. Full stop. It was unable to be disputed by the department that the SSC did not have an opportunity to challenge the said statements, and further, no opportunity to cross-examine the so-called entry providers. Full stop. Paragraph. Having heard learned counsel for the department and having perused the impugned orders of the AO, the CIT bracket A and the ITAT, the court finds that both the grounds, namely the claim for the benefit of section 10 bracket 38 of the Act and denial of an opportunity to cross-examine the entry providers, come up purely turned on facts. Full stop. The ITAT was justified in accepting the plea of the SSC, since the failure to adhere to the principles of natural justice went to the root of the matter. Full stop. Also, the CBDT circular that permitted the SSC to file revised returns if it forgot to make a claim was also not noticed by the AO. Full stop. In the considered view of the court, the ITAT committed no error in concurring with the view of the CITA in dismissing the revenues appeals. Stop. No substantial question of law arises from the impugned order of the ITAT that calls for interference by this court. The appeals are accordingly dismissed.
Up to 31 same, my lord.
Up to 21 same.
But my lord, some cases 19 days or some cases 20 days delay.
Everywhere delay condoned. All right.
Please just.
All right. Up to 31.
Well, item 37, I am getting the photographs. Will also take up the matter after launch, my lord.
All right.
But I have got some photographs. I am getting it printed, my lord.
You show it to him, sir. Mainly showing it to him only. You got it on my phone.
I am also trying to contact the sub-collector.
All right. 2 o'clock. 2 o'clock.
What IIC told me over telephone that this is a separate compound near the school ground. But traditionally the mela is going on that
Correct.
particular place. And school functioning is not at all affected. That they are ensuring. That your lordship can observe in the order if your
As long as they give that assurance, that's okay, sir.
school functioning will not be affected at all. That the district administration will ensure.
Yeah, that is inevitable. We are all
That
used
was
to
also the earlier observation by this honorable in the previous writ application.
Yes.
If it is organized in the school premises, it be shifted to any other place.
No. If
So-
your lordship may kindly imagine 5 days already expired and another 5 days. Your lordship can direct if your lordship
So
so
it is
that
till
the district
16.
administration should ensure that is normal functioning will not be.
This open space is not like Revansha Collegiate School. You mean to say that?
No.
No, Revansha Collegiate School has.
No,
same
this is also a
compound.
big school. What I
That is same compound.
Yes, same compound.
compound is same. Your lordship can imagine compound is one, but the playground is always outskirt of the school. School
No,
and
that is the-
playground that can be divided.
That the divided.
And in small places, getting a big ground for Mela is also very
Well, there are big
So-
patches of land. There are big patches of land where
you should have come prior to the commencement of Mela, not at this stage. After 5 days is completed for another 5 days. If how we will stop the Mela, it is against the public
so
sentiment.
there is no
also.
question of 5 days, completion of 5 days. They started it from 7th. Saraswati Mela was started from 7th. Well, on the guise of
So at the
Dumusa.
meets, your lordship, ma'am, imagine at the meets, how we will stop the Mela. And the slot, you are only one. The petitioner is only one. And the entire people of Udala, at least 10,000 population,
But
they
there
are
was-
enjoying the Mela.
But concerning this subject also, there was agitation by the local public before the collector.
Where is that material? Where is that
The
material?
representation is there. Representation,
Then
the,
representation will be considered.
the person is not one.
In any case, if your lordship
That
will direct the
data
district
part
that
that
we
data
will
part will
ensure
earlier-
that the normal functioning of the school will not be hampered.
All right. The apprehension expressed in the present petition is that permission is being granted by the local administration at Udla in Mayurban district for holding of single quotes Dumusa fair, unquote, in a school premises, which might adversely affect the interests of the students preparing for the annual exams. Paragraph. On instructions, Mr. D.K. Manti, learned AGA, informs the court that the Mela is not being held in the school playground public premises.
Not being held. It is not.
It's
It
not
is being held in
school-
the playground.
school premises.
Playground, in the
Yes.
playground,
Okay,
and
being
which
held
is
in the
not
school
affecting
premises,
the
but-
normal
yeah,
functioning of
but-
the school.
But in the playground, which is adjacent to the school
Yes,
and is no way affecting the
normal functioning.
normal, functioning of the school or adversely affecting the students. Paragraph, the court would like to emphasize that the local administration should ensure that the holding of the Mela does not hamper the actual conducting of classes in the school or disturbing the students in any manner whatsoever.
That is fair enough. Your lordship. Your lordship may direct that this order be communicated to the sub-collector Kapti Pada.
All right. You say this order be communicated to the sub-collector
Sub-collector Kapti Pada.
Kapti Pada, District Mayurbanj forthwith for implementation.
Your
Petition
lordship,
is disposed.
yes. Lordship observe only after, if there is any Mela, that will be after school hour.
No, that is
So,
schedule.
leave it at that.
So how it is affecting?
No, this
If
is
my
not.
lord,
This
if
is
my lord
only
senior
going
is submitting,
beyond
then it's
this.
not, no,
It is
not
highly
going here.
unreasonable.
Not-
That is Mela schedule
No,
is.
why unreasonable? This is the unreasonable on
The
the part
only
of the
one
administration.
person is claiming that all this.
This is the unreasonableness on the part of the administration. Well, in spite of the previous order of the Supreme Court, they are insisting to organize the Mela in the school premises.
All right.
What my lord senior is submitting is a politically motivated. This is only politically motivated.
All right. No, all the more why we should stay out
Then
of
you
it.
are also a politically motivated petitioner.
Maybe.
Then you
Then
say
all the more
that
why the court should actually stay out of it. Yes.
this PIL should not be entertained at your
Yes.
instance.
Item 40.
Obliged.
Yes, Lordship. I am for the petitioner. Lordship, there is a provision for revision under section 253 of IT Act.
Option one.
That is the appeal, my
Yes,
lord.
sir.
Appellable order against the revision of appeal lies to the.
Counsel with the petitioner seeks leave to withdraw the present petition with liberty to file a statutory appeal as provided under the Income Tax Act against the impugned order. Of the principal CIT.
Yes.
Under section 263 of the Act. Stop. If such appeal is filed not later than 3rd April, accompanied by an application for delay, explaining the delay on account of the pendency of the present petition, will be considered in accordance with law by the ITAT. The court clarifies it is not expressed anywhere in the matter.
Okay.
I'm
The
appealing
writ
for
petition is disposed of, is withdrawn, with liberty is prayed for in the above terms. All right.
Item number 60. It may please your lordship.
Anchileka High School.
60. My lord, the appellant has challenged the order of Honorable Single Judge under Annexure 2, my lord.
No, it's 4 and 5 are served now. Respondents 4 and 5.
5, my lord, respondent 5. 5 with the
Haladar Sahu.
Haladar Sahu with the petition, read petitioner.
But I have appeared already.
4 is the headmaster, my lord. That 4 is not necessary pro forma party. Because the headmaster cum secretary has filed this writ appeal.
I see.
The limited question is, your lordship set up.
Let me complete my submission. Let me complete my
2022.
my lord, let me complete my submission. What is the illegality has been committed? Well, the opposite partner 5 was appointed as fourth peon in the Acharika High School, Kegaon, which is an aided educational institution, my lord.
My lord, for the state, copy not solved as per your direction. Opposite partner 1 to respondent 1 to 3.
Copy has been solved on here.
My lord, kindly see the order dated 20.
My lord, solved on 2/11/2022, my lord. 3 extra copy has been solved on there.
No copy.
No copy. 2/11/2022, I have solved.
All right. One more copy be served. Appeal memo on counsel appearing for opposite parties 1 to 3.
1 to 3.
Within a week. List on. Ninth August.
May I pray one thing more, my lord? Your lordship issuing notice as to whether who will pay 75% of the area. But despite the order in 2018, I should be reinstated. Till that, I have not been reinstated. That order has not been interfered with. Your lordship, the notice limited to the question who shall pay 75% of the back wages of the
You say, since the notice was issued in the present appeal on a limited question, the respondent number 5, if not already reinstated, should be reinstated in the meanwhile.
My lord, one thing, it is, my lord, contrary to the judgment of the Honorable Supreme Court, reported in 2003-10 SCC 411.
That's all right, sir. We should notice only a limited question. All right.
For admission item 60. That direction should be given to the district education officer, my lord.
We're not, just said
he is the authority. I am not the authority now.
Whatever. All right.
Item number 64.
64, my lord. To 60 days delay, my lord.
260.
Yes.
The delay is not condoned. Accordingly, STREV is dismissed. The question of law is left open for decision in some appropriate case.
Item 65.
The present petitioners are the allotee of the shop rooms with the Bhubaneswar bus stand, my lord, by the Orissa State Road Transport Corporation, my lord. In this, the notice was issued to them to pay the service tax, my lord. As per the adjustment of the service tax limit is 10 lakhs, my lord. But the petitioner is only shop owners was paying the rents only. And the service provided the business.
We demand notice, sir. You have to seek other appropriate remedies. Service tax demand, you have other remedies. Leaving it open to the petitioner to avail of the other appropriate remedies against the impugned demand of service tax The petition is disposed of. The interim order is vacated. Right.
And I am appearing for the OP.
All right.
I am giving.
All right.
Connected.
Yes, yes. Same order.
Item 66.
Lord, may I please, Lordship? Lord, this is covered by your Lordship's judgment in Kalyani maternity.
SLP has been dismissed, my lord. That is the order, my lord. So your lordship's order remains valid, my lord.
So that's correct. It is
This petition can be disposed of.
Lord, Kalyani maternity, that is WPC number 6590 of 2012. It's judgment by your Lordship and Justice Rao.
That's been upheld.
That has been upheld by the Honorable Appeals Court. That reference gives WP.
I have given copy.
So now what happens?
It is to be quashed. The impugned order is to be quashed, this Sanishchar one.
All right. The court has been shown a copy of the order dated 7 November. Make a note, tell make a note in our compilation. 7th November 2022 passed by the Supreme Court of India in SLP Civil 19268 of 2022, dismissing the SLP filed by the Bhubaneswar Municipal Corporation against the judgment of this court dated 22nd April 2021 in writ petition civil 6590 of 2012 bracket Kalyani Maternity Hospital Private Limited versus Municipal BMC, whereby this court had quashed the
determination of holding tax as per the new one.
Levy of holding tax, levy and collection of holding tax, single quotes holding tax, unquote. Full stop. In that view of the matter, the impugned order dated 1st October 2019, rejecting the representation made to the present petitioners, is hereby set aside. It is clarified that consistent with the judgment of this court in Kalyani Maternity Hospital Private Limited Supra, no holding tax can be levied or collected from the petitioner. Except in accordance with law. Correct. The petition is disposed of.
This is to be quashed this one day.
Sorry?
1st October, Annexure 1.
We've set it aside. I think Annexure 1 has been set aside.
I pray for a small accommodation. This item 80 hearing, because today is the death anniversary of my father-in-law.
Okay.
In father, I can take an excuse.
No, item 80?
80 some other day. Any day, that is also the same Bhubaneswar Corporation matter. And that was linked along with this. So that is with regard to user fee. Maybe
Mr. Manas Mahapatra has very strong views on that.
I think Lordship, in fact, directed the petitioner to file a affidavit, additional affidavit filed by the state the last date. So that rejoinder not been filed by the petitioner.
So we'll just, he needs an accommodation. All right. You said item 80, Mr. Pitambar Acharya and senior counsel for the petitioner is in some personal difficulty today. So list on 9th August is a very good date, sir.
Why not?
That's the let's fine. Yeah, interim order to continue.
We hope a lot of things before that. Before that. we want to see you in continuation in some other forum.
But we'll celebrate on 15th August.
All right.
Let declare blessed.
Item number 67.
Council for the state.
Item 67, this pertains to that damaged road.
Because
on the last occasion, I had shown some photographs of the instruction. So we were supposed to complete it by January 2023.
What happened?
However, the same has not been completed yet. I've got photographs today also and instruction. So,
You've seen it?
Not,
See, you should go there yourself.
Madam.
How will you counter this? Or ask someone to show you live. Now technology is there, sir.
Madam.
All villagers, everybody's got mobile phone now.
well, it's by the end of this month we intend to complete it, because there were two
Now it is
issues.
stated, okay, now Mr. Ishwar Mohanty states on instructions that the work of constructing
The road from SH10A to
dry lean concrete road with pavement will be completed by the end of February 2023. List on. You keep it towards the end of March so that you're not again embarrassed.
Yes, sir.
Madam.
29th March.
Probably.
Item number 68.
I may be pardoned, submit me, Lord. My prayer before my lordship to construction of foot over bridge in Chhatrapur main station, my lord. It is incomplete, my lord. Thereafter they didn't come, my lord.
Where is the railway? Your railways.
Now what happened, my lord? They highly reply, my lord. Something is wonderful. Regarding construction of a railway foot over bridge, nothing is there, my lord.
Which is a good thing, sir, which means they might build it also.
No, my lord, they are saying it is not a maintainable.
Oh.
That is a word is used generally.
Bridge is not maintainable or your petition not maintainable?
My simple prayer before my lordship, it is the station was in 1899. Railway station of Chhatrapur. And there number of people are suffering. They should construct the foot over bridge. That is my sole prayer before my lordship. They are not doing so. They are saying that it is not maintainable.
My lord, I have mentioned in para number 6, my lord, the averment made in paragraph 5, the writ petition disputed and denied the opposite party in reply submitted that proposal for extension of foot bridge already sent to railway board, my lord.
That's not enough, sir. When was proposal sent? Now you're also railway board.
Yes.
When was proposal sent? What happened to the proposal? How many people should die for you to get the proposal approved?
I have just
my whole prayer before my lordship, number of people are suffering, my lord. It is, the station was in 1899 British. There was the main station of railway station, my lord, in Chhatrapur. Everybody knows it. But they are not, they are illiterate people. They are suffering like anything. They are not doing.
Illiterate, they are not, sir, but
suffering. There are number of people killed, number of cattle damaged.
Yes, yes.
My lord,
when was it sent? When was it?
Pending, my lord, already.
Sorry?
My lord, already pending proposal for extension.
Since when, sir?
My lord, for proposal 2024 and 23 and 24 proposal. Page number
when
3.
was it sent?
Page number 3, my lord.
No. When was it sent, sir? You have to give details. The affidavit is there.
Yes, ma'am. That is not mentioned there, ma'am.
The preliminary counter affidavit filed by the railways, East Coast Railway, is bereft of the particulars as to when the proposal to extend the foot overbridge in Chhatrapur station towards platform numbers 4 and 5 was sent to the railway board. Stop that. A further affidavit shall be filed explaining the precise date on which the proposal was sent and what has happened to the proposal after it was sent. Stop. A separate notice be issued to the there must be some member. Which member of the railway board will be? In the railway board, which member is in charge of all this? Proposals. There must be some member.
Affidavit filed by divisional and engineer South, my lord.
No. If it is pending the railway board, they'll all simply say it is pending the railway board. To the secretary.
Secretary was the party. My lord, I made a party also read petition to exhausted all opposite party. But they are saying a new thing, something is pending.
No, railway board is the ultimate authority, sir. So all these parties will simply tell you it's pending the railway board. Send the railway board to the secretary. Something called secretary railway board. Just see the website of the railway board. And just go up, go up, go up. Railway board. Oh, no, further, come down, come down. Infrastructure. Just move this. Oh, no, here. All right. Separate notice will issue to the principal executive director bracket infrastructure bracket of the railway board to inform the court on affidavit what has happened to the proposal sent in this regard and how soon will steps be taken to implement the proposal. The registry will ensure that the present order along with a copy of the petition will be emailed to the principal executive director bracket infrastructure railway board for compliance. List on. But this was just for information.
My lord.
What we did is went on the website, found out which person is dealing with these issues. This is for your future reference. When you file petitions like this, you should know how the railways work. List on 29th March.
Item number 69.
Wait, your lords. My lord may see my lord's last order dated 22/12/2022.
Where's Mr. Padi is there? Or?
My lord, two things have been done, my lord. My lord, here I had drawn my lord's kind attention.
No, where is Mr. Padi?
I am on behalf of Mr.
You are appearing in the
My lord, in paragraph 2 of the order, my lord, my lord was pleased to refer my submission and with regards to payment of 6 lakhs. And Mr. Mahanti was instructed, directed to verify.
So, the state does not have a separate special policy with regard to this particular disease. But what we have said is that, my lords may see what we have said is that under the BSKY scheme, these patients can avail, because the upper limit is 5 lakh, that is the upper limit. So they can avail cashless treatment up to 5 lakhs in the empaneled hospitals under the BSKY.
Good enough, sir.
My lord. And other things, my lord, on being directed by the AIMS Bhubaneswar, my lord, one of the petitioner, my lord, who has been mentioned in A, my lord, Mr. Das had been to Center of Excellence, Calcutta, with the list of the patients, my lord. So authorities directed that we will send the intimation to you for attendance. But though, my lord, he had attended on 21/12, but till date, no intimation has been received by them, any of the patient, father of any of the patients, about attending the Center of Excellence, Calcutta.
It should not be one empty format.
We will find out, the lordship.
We'll find out, Lordship,
Or
on this matter after 7
Each
days.
day is valid important
Correct,
for this type of patients.
Correct. Mr. D.P. Dalal, senior counsel appearing with the petitioners, points out that pursuant to the order passed by this court on 22/12. When did they go, sir?
They had gone valid on 20, they had gone on 21/12. One day prior
before
to
the day. I see.
1 day prior to passing of this order.
No, that
He was called by the AIMS ballot, Director AIMS, and
Ames where? Calcutta.
no AIMS Bhubaneswar, on being directed by him to go to Calcutta Center of Excellence, and he had met the authorities there.
No, when?
On 23rd December, madam.
All right. It is stated that the that as offered by the Government of India in its affidavit dated 9 November 2022. Whom did you say, sir, went with that list?
Ballot?
No, you said a person went with the list.
Sangramjit Das, who is the father of ballot Satyamanu Das. Well, let me see my writ application, page 7. A, patient number 1. A, Satyamanu Das, his father Sangramjit Das had gone with all the papers.
All right. Mr. Sangramjit Das.
Sangramjit Das ballot.
Sangramjit Das, father of Satyamanu Das,
Ballot.
had approached the Center of Excellence in Calcutta
With all the
with
papers
the list
of all
of
the patients.
the entire list of patients who would require treatment, and was informed that they will be sent separate intimations of the dates on which they should receive treatment. Full stop. He states that till date, no such intimation has been received by any of them. Full stop. Counsel appearing for AIMS Bhubaneswar states that he will seek instructions forthwith, and after getting in touch with the Center of Excellence in Calcutta, ensure that intimations will be received by each of the patients whose names have been furnished to the said institution about the dates on which they should come to the Center of Excellence at Calcutta to receive treatment. Full stop. On the next date, the court will be informed of compliance with this direction. Paragraph. As regards the benefits extended to children suffering from Duchenne muscular dystrophy, bracket DMD, in Orissa. Mr. Ishwar Mahathir, an additional standing counsel, has placed before the court written instructions dated 30th January 2023 received from the Joint Secretary to the Government Health and Family Welfare Department, stating that beneficiaries of the Biju Swasthi Kalyan Yojana, bracket BSPY, are eligible for cashless treatment coverage of rupees 5 lakh per annum per family and an additional rupees 5 lakh for women members. Full stop. It is stated that a patient of DMD can avail the cashless treatment under BSKY empaneled hospitals under single quotes unspecified package up to an amount of available balance in the wallet. Full stop, unquote. This statement is placed on record. See list on.
May I just, with your lordship's permission, they are saying that in the empaneled hospital, and now we have been referred to AIMS Calcutta, which is not an empaneled hospital. That your lordship may consider. I have nothing more to add.
Center of Excellence.
Yes, ma'am. Center of Excellence at Calcutta. So the government of Orissa is showing the list of empaneled hospital at Orissa for the eligibility under the BSK.
Outside also.
Outside
This
also.
is outside.
I'll have to check if this is not there, I'll just take instructions.
All right.
And ask
Mr. Mahanti adds that he will seek instructions on whether the centers of excellence outside of Odisha would also qualify to be considered as list of empaneled BSKY hospitals. All right.
If not, it's there, then it may be. Otherwise, we will not get it.
Considering the peculiar problem faced by the person suffering from TMD, the government will issue a further clarification in this regard. All right. Government of Odisha will issue. Full stop. List on
15th March.
Sorry?
March period, in the month
Yes,
of March. Because of my lord, only my lord we are getting this.
2nd March.
My lord.
And the last item, that is 35002. In that case, I am appearing, but my name is not appearing for the Union of India.
Yes, all right. We'll put down his name.
That order may be applicable to 35002.
It is applicable to all cases.
All right.
Item number 70.
70, my lord, I need some more time for instructions, my lord. On 31st 10/22, we have taken time for instructions, my lord. No instructions has been come, my lord.
At the request of Council, the department who needs more time for instructions list on. August 16th. Interim order to continue.
Item number 71.
Similar matter has been posted for September 2022.
On behalf of Mr. S.K. Dalai, the matter may kindly be similar, two similar matters have been posted to 4th September, my lord,
Correct.
by this honorable court.
Yeah, list on 4th September. All right.
Interim order to continue, my lord.
Interim order to continue.
Item 72.
Obliged, my lord.
72, we have already filed a counter, my lord.
That's as a last chance, I pray for 2 weeks' time to file rejoinder.
All right. Rejoinder to be filed before the next date.
Interim order to continue.
Interim order to continue. 16th August. All right.
Item 73.
16th August. Manners. Yes, just after independence.
May I please?
Yes, please.
73, my lord, time to file counter. First appeal GST matter, my lord.
Okay. For the 8 weeks time is granted to file counter. Rejoinder for the next date. Interim order to continue. Yes. Same. 16th August.
Item 74.
In item 74, your lordship, in compliance to the direction of the SBI LDR 3 by the designated committee, I have made 4 attempts, your lordship, for repayment, your lordship. On the 4 occasions, your lordship, although money has been debited by lords, on the same day it has been credited to my account. My lord, in the similar circumstances, my lord, in the case of Happy Travels, your lordships, following the order of my lords in the case of Nagam Hospitality, directed to the opposite party to issue the masters manually, your lordships.
and the opposite party is following the direction of the my lords have already issued the manual the SBLDR 4 lordship.
What does it say in the counter?
My lord,
In the counter, what does it say?
Para 4, my lord. 30 days time is given to make the deposit, my lord. And then
No, but
that's last
technical
date.
error, he says, sir.
Yes, last date was extended thereafter. Even after the extended period, my lord, he has failed to deposit.
Fail meaning he says whenever he tries to do it, it's not accepting.
This is a mechanical process, my lord, entirely electronical. He has to do it, but it's his duty to make payment.
How is he supposed to do, sir? If everything is electronic, online payment,
yes, my lord.
how is he supposed to do it if it doesn't accept?
my lord, page 4 of the document submitted today, my lord, is
I think
directed.
the same happy travels order will pass, sir.
Yes, my lords.
You say the court has perused the counter affidavit filed by the opposite parties. Full stop. Apart from merely stating that the petitioner has not made the payment within the extended time, the counter affidavit does not acknowledge the technical difficulties faced by the petitioner in making such payment as has been explained in the petition. Full stop. If the system is unable to permit the petitioner to make such payment, as a method will have to be worked out by the department to deal with such contingencies by permitting manual processing of the manual processing. Full stop.
There's a circular, page, para 19.
Your reply has only 12 paras of the judgment. Right. In similar circumstances, this court referred to the instructions dated 17th March is in its order in Nagan Hospitality Services Private Limited. There's a Central Board of Indirect Taxes and Customs 2021 50 GSTL 518 Orissa. Had noted the instructions dated 17 March 2021 issued by the Department of Revenue permitting such manual processing of the declaration filed under the SVLDRS rules 2019. So, paragraph, the present petition is according to disposed of. With the direction to the designated committee, SVLDR scheme, bracket opposite party number 5. To accept the payment of rupees 30,25,811.40 as per SVLDR-3 dated 25th January 2020 and to issue the SVLDRS-4 in favor of the petitioner. By either accepting manually or by opening the web portal to permit online filing specific to the petitioner. This direction be complied with within 4 weeks. The petition is disposed of.
My lord, phrase SPLDR may be issued, my lord.
Sorry?
Phrase SPLDR kindly be issued, my lord.
I think
Phrase SPL 3, my lord.
And issue SVLDR-4, we have said that. Right.
Grateful, my lord.
Item number 75. 25, 76, my lord. More time to file counter, my lord. First appeal GST matter.
Reply we file within 8 weeks. Rejoined appendix. Interim order to continue. 11 September.
Grateful, my lord.
76.
Same.
Same, my lord.
All right.
The interim order to continue.
Have said.
Item 77.
My lord, 75 interim order to continue.
Yes, yes, I've said that, sir.
Obliged. Item number 77.
Lord, there are developments taken place in the meantime. Lordship could see annexure 1, page 9, that is subject matter of challenge here by the excise deputy commissioner. Lord, the shop in question, in fact, stood closed from 9th of May 2015 because of the huge public objection. That report is available, that your Lordship will find it at page, my lord, at page 13. The excise authorities report 9/5/2015 shop remained closed due to serious public objection and they did not allow to open the shop. Page 13, man.
Yes.
Now, pursuant to this, the excise authorities passed an order to me that I am to shift the shop to a non-objectionable site, annexure 6, page 14, man.
Yes.
Now, thereafter, I applied for shifting, which is apparently 35 kilometers away. That's their own report is, my lord. Page 16. 35 kilometers away from the existing site.
Yes.
Is that clear, man? Now, your Lordship, see, after I pursuant to this report, they did not allow me to shift this up on the ground of this distance. I approached this honorable court. Now, this honorable court passed an order setting aside the order directing to reconsider, referring to Khamardi Samal's case, that distance cannot be a factor, directed to reconsider me. Now, they reconsider it and directed me, kindly see annexure 1 now. Directed me to submit an undertaking, written undertaking from the licensee to pay consideration money till the year 1920. Means my shop is closed since 15. I'll submit an undertaking to pay the consideration money for 5 years. Then I'll shift the shop. Then next paragraph, your Lordship may see, the commissioner is considerate to get a report from the collector to reduce the MGQ, para 5. Now, my lord, the development is in the last lottery, I have even lost my license. It is no more available to be shifted. So only question is the MGQ and license fee for during this period, I do not have admittedly license. So it is to be waived. Either I'll approach the commissioner or the collector or the government, to whomsoever my learned friend Mr. Mahanti agrees.
No. Till date, you have not been served with any demand notice. Now the shifting matter is under challenge in this writ petition. That has become infructuous. If at all any demand notice will be issued to you, then it is open for you to challenge it in due forum.
Okay. You see, due to passage of time and subsequent developments, counsel for the petitioner states that the petitioner no longer has a license to operate any shop, and therefore the question of shifting of the shop does not arise anymore. Stop. As regards the waiver of the MGQ for the period during which the shop was closed, Mr. Mahanti states, as and when any demand is raised on the petitioner can always seek appropriate remedies in accordance with law. So, placing on record the above statement, the petition is dismissed.
Yes, MGQ and consideration money, both.
Oh, yeah, MGQ and consideration money.
Right, correct.
All right.
78.
May I please? It is not, madam. And the appellant in this case, madam, all the batches case, madam. It is filed by the Orissa State Transport Corporation, madam. The sole issue here is, my lord, whether the revised scale of pay adopted by the government will applicable to the employees of the corporation or not, my lord. The revised scale of pay, my lord, was by the government was issued in the year 1998, but the corporation adopted it in 2008, my lord, due to financial crisis, my lord. And the learned single judge has, in this the application, my lord, has directed the corporation to issue a modification order dated 18/2/2009 in the line of ORSSP Rules 9080 being applicable with effect from 1/1/1996. All the petitioner are, my lord, applied for the VRSS here and they are voluntarily retired in the year 2002, my lord. The revised scale of pay, my lord, applied to the employee of the corporation in the year 2008, my lord. Your lordship can have glance page 13, my lord. of the writ appeal, madam. Paragraph 17, madam. Your Lordship, may I read, my lord?
Yes.
My lord, office order, my lord, your Lordship, may I can- implementation of revised scale of pay 1998 in respect of OSRT employee. In accordance with the finance department resolution dated such and such, read with finance department notification such as approval of the government in city department, communication by letter dated 16/2/2009, the revised scale of pay 98 is applicable to the employees of the OSRTC, including the employee erstwhile URT, O1 STS employee now on deputation only. The revised scale of pay 90 shall be effective from the 16/2/2000 with the following condition. These petitioners, my lord, were already retired from the service by getting VRS, my. So my lord, I have given a death chart, my lord. Your Lordship may can have a glance to the death chart. Your Lordship, in 1/5/1974, my lord, Orissa State Transport Corporation was formed as per the provision of Road Transport Corporation Act 1950, my lord. On 21/12/1970, respondent 1, my lord, was appointed as a ministerial servant, my lord. On 13/1/3/1978, my lord, state government frame Orissa employee classification, recruitment and condition of service regulation.
Who's appearing for the employees in all these matters?
Yes, my lord.
You're there for all the appeals.
In all the
All.
two cases, but I am reading the cases.
All right. Yes.
My lord. In the year 13/1/3/1978, my lord, the state government has framed Orissa State Employee Classification, Recruitment and Condition of Service Regulation 1970, in which there is no condition that the scale of pay and DA of the state government will be applicable for the employee of OSRTC. The scale of pay of the employee of OSRT were fixed as per the ORSP rules 1980 with 10% of DA, my lord. The increase in DA given to the government employee could not be allowed to the employees of the OSRTC due to poor financial condition and continued losses. In the year 1996, claim of employees of OSRTC for higher DA at par with government servant was referred to Industrial Tribunal in ID case number 140 of 1996. On 1/1/96, pay revision as per the ORSP rules 1980 was made applicable for the government employee only. The benefit of pay revision could not be allowed to the employees of OSRTC due to poor financial conditions.
When was it made applicable?
My lord, on 2008, my lord.
So from 2008, they are entitled to?
They have already retired by VRS, my lord. In the 2002,
will
my
the pension get correspondingly revised?
No, there is no provision pension, my lord. Provision of pension for the corporation employee.
Oh, no pension at all?
No.
Oh. How do you justify it, sir? You come to the court in 2011, correct?
My lord.
You filed these writ petitions in 2011.
Yes, my lord.
So how many? 13 years afterwards and 3 years after revision?
No. 2009 it was implemented. Your lordship may kindly implement.
You retired in 98.
Not 98. After 98, the ORSP rules came into force
When
by
did you
the
retire,
by the
sir?
government.
When did you-
After that, you have retired.
No.
When? That is 2002, 2003.
Whatever. So
What happened, my lord? That time, that pay fixation was not introduced by the corporation.
So
It was
2008
introduced-
it was introduced.
Yes, ma'am.
Why did you wait till 2011?
That was not available, so there we cannot challenge.
2008 it was available, sir.
No, that was applicable in 2009.
Okay, why did you wait for 2 years?
When it was, we have represented when they did not give again.
Once you're retired, how can you get that revised pay? Once they've adopted it only in 2009.
Then I'll clarify, my lord.
Right.
We were two sets of employee. One from the STS and one from the direct recruiting. Your lordship kindly have two sets of employees are there. Two sets cases were filed. And both the cases were disposed of by common order, similar type order, that they are entitled for the benefits from the 1998. And those the employees, those have come from STS, and their case only allowed here in the writ appeal and as per the government guideline, and that's why these cases were segregated from there, and that judgment was passed That and these persons were left out only. My respectful submission, my lord. After 1974.
What is the judgment you are?
Yes, my lord.
Well, I am clarifying, my lord. There are two sets of employees.
Two sets
One
of
from
employees?
the STS, my lord,
Yeah.
who are on deputation to the corporation, and others are direct employees. And in case of STS, my lord, who are deputed,
means what?
they are eligible for
What is STS?
Yes,
my lord,
that-
state transport
Transport
service.
Authority.
State transport service. Before
Service.
my lord, before 1974, there is a state transport service, my lord.
ORT.
My lord?
ORT.
ORT.
Oh, yes, my lord. Odisha Road Transport and STS, my lord. They are claim and we are allowed. They have get their revised scale of pay, my lord.
So my
As
responsibility
per
is
they
clear.
are government employees.
So my responsible submission, there is a clear discrimination as because those after 1974, both the became one cadre and the same nature of a duty. And but since they were allowed the benefit, that only differential salary from 98 to till their retirement, that is 2004. That's why their cases were withdrawn as because they have been allowed the benefit. My respectful submission, I have given a judgment of this the Honorable Supreme Court regarding Article 14 in this type of case. I have that is attached with my death chart. Your Lordship may kindly see that in 2017 2 OLR Supreme Court 503. This is available with my death chart. Government has a sanctioned money for STS and others, but they mean that it is for the STS. If your Lordship will kindly see the order. And these orders are available in that 373 order. And that was segregated. That's why those documents are not available here. All were taken together. After that order, these cases are segregated from this. Your Lordship may kindly see. And this order, the government has sanctioned only for, not for STS, but for all. Your Lordship may kindly area claim. The order dated 2010-2018. Your Lordship may kindly clause 1. Claims of erstwhile employees of STS and others. So government has sanctioned money for the benefits for all, but they mean that it is only for STS. If we are in one cadre, we have been allowed similar scale, all the scale, revised scale, and they will be allowed the claim, but we will be left out. Is it not clear case of discrimination, my lord?
So how can you claim parity with STS?
As because after 1974, they came from the STS, we are directly recruited. We came into one cadre and same nature of duty and same scale of pay, and in all previous pay fixation, we have been allowed same benefit. Though in all previous stages, the revised pay scale were given later, but from the date of the implementation of the pay fixation. All we have been given. But here we have also retired, they have also been retired. And in 2009, it was applicable with prospective effect. That's why both we filed the cases. That 373 cases, and in the pendency of the case, both the cases were allowed by the Lord and Single Judge. Only one ground, if your Lordship kindly see that judgment of the Lord and Single Judge, your Lordship only one ground.
For STS people, from which state have they given it, sir?
Yes, from 98 to the date of retirement.
No. Show me an order that for STS they've given it from 98. Where is that?
No, according to this order, my lord.
What?
They are given.
Which order?
Accordingly, the case was withdrawn. The government has pleased to give them a benefit.
Have they, from which date have they given the benefit?
From 1982.
No. Show us, read, don't orally say, sir. Show us a document which says for STS employees, the benefit has been given from 98.
I may be giving some little time. I will give you
this all back. Counsel for the respondent needs some time to produce documents to show that for the state transport service bracket STS employees, the benefit of revised pay scale employees of the OSRTC, the benefit of the revised pay scales of the state government was in fact extended from 1198 onwards. Full stop. That is request list on 21st August.
Item number 79.
Not 21st, sorry. 23rd August. 23rd August. Right.
Item number 79, my lord.
79.
Both these appeals, I have already entered appeals in respect of respondent number 2 to 5, my lord. I have already filed my Bokalana yesterday, my lord. 2 weeks time may be given to file the reply, my lord.
No, writ appeals, no reply is required.
They are not required.
Not required. In fact, the issue is left out with some of the respondents against whom the notices are come back.
No such addressee in that address
Yes.
and all that.
So in fact,
Substitution that IA 392 allowed has prayed for the consolidated cost title be filed with the levy.
Right.
You say all such respondents who are yet to be served, fresh notice will be issued at the addresses to be provided by the counsel for the appellant within 4 weeks. Full stop, where reports have been received stating a particular respondent is deceased, the appellant will take steps for substitution.
yes,
List on
in the connected appeal also, I will follow up the
23rd August, both these. Right.
23rd August.
entry order which is
The detail is called from where we stopped. So all the other matters can wait. Run through the
Weekly list. Item number 31.
The cancellation of lease matter, my lord, the petitioner is the subsequent purchaser, my lord. He was not giving notice to hear.
What's the date of your sale deed?
Is
Sell deed or date.
sale deed, my lord, 82.
86 or 82. I'm
82.
sorry. I'm sorry. 80.
On the short ground that notice was not issued to the present petitioner, who is a purchaser from the original lessee by under register of the property in question under a registered sale deed of 1982, before passing the impugned order dated 19/9/87 of the ADM Bhubaneswar, it is hereby set aside, and revision case number 672 of 1987 arising out of WL case number 470 of 1974 is restored to the file of ADM Bhubaneswar, where it will be listed on 5th April 2023. We'll stop on that date. The petitioner will appear through an authorized representative. The ADM is requested to proceed afresh and dispose of the said revision case within a period of 4 months thereafter. Till such time, the interim order dated. Oh, there's no interim order here. Till then, status quo shall be maintained vis-a-vis the property in question. Petition is dismissed.
Obliged.
Weekly list item 32.
None appears dismissed.
Weekly list item 33.
May I please, your Lord? Well, I have challenged Annexer 1, an order of the Labour Court. Admittedly, the so-called workman is my power of attorney holder. He looked after work on my behalf and directly approached the Labour Court under 33C2 without any predetermination. And the Labour Court entertained and passed a money decree.
Has he been served?
Yes, he is appearing.
Who is appearing for?
Mr. Jenna was appearing.
Where is he? It will stay on board. Let him come, sir.
Item 34.
Well, it is passed over, man.
Item 34, kindly pass over.
Item 34, kindly pass over.
Who's appearing? On whose behalf are you seeking?
Well,
pass over?
I am appearing for the petitioners. Conducting
There
counsel.
are two kind of matters. Management has filed some cases, and in one case, the my lord workman is a petitioner before your lordship. Listed.
The payment has been made to the workman, 17B.
In
Yeah,
fact,
my lord.
entire payment has not been made. They have made some payment in the meanwhile, but they are not making the full payment. That is the whole difficulty.
My lord, in this matter, out of 4 cases, in the 3 cases, since the counsel for workmen was not appearing, this honorable court has asked me to assist the court, my lord. What I find, my lord, in these 3 cases, IA is pending to pass a similar order that was passed in 652, that is to pay the 17B wages as per the Minimum Wages Act. That petition is pending, my lord. IA is pending.
Why don't you make calculations, Mr. Mishra? Why don't you people give the calculation, then we can put it to the petitioner.
Well, I'll give the calculation. Here, my lord, in fact, 11 dues are pending.
Sorry?
11 number of dues are pending.
So, my lord, last occasions, my lord, I have already asked for direction of the honorable court, my lord. The check I'll only hand over to the workman, my lord.
Which workman?
My lord, the OP number, the London Council, my lord, is appearing on behalf of the OP number 2 lordship in 652. And if my London senior is saying that there's 11 checks, let them submit.
He has given 3 checks on 1/2/2023 to my client who has received it. And as for the instruction received from the client, still 11 number of.
Both Mr. S.K. Mishra, Learned Counsel, appearing for the workman in writ petition civil 652 of 2012. And
in other amicus, I have been assisted in other 3 matters.
And Mr. So appearing in the for the workman in the other 3 matters state that the section 17B wages have not yet been fully paid to the respective workmen. Full stop. Each of them will provide the detailed calculation of the outstanding 17B dues to counsel for the petitioner within 10 days. Stop. The counsel for the petitioner will ensure that the 17B dues are fully paid to the workman before the next date. List in the regular list of matters on 4th May.
I only point out that in WPC 652, there was a direction that the 17B wages should be calculated as per the Minimum Wages Act.
That's obviously. So when you make your calculation, you'll show them accordingly, sir.
My lord, 654 is, my lord, the petition is died, lordship.
654?
My lord, the WPC number 654 of
54 of 2012. Who's appearing in that?
My matter, my lord, where the workman has come up.
Sorry?
That is my matter. The workman has come up, my lord.
Against what?
Against the same award. Against the same award, challenging the part of it, my lord. That is also for your lordship.
All right. Or at least the same date.
Item number 35. To make a mention, your lordship. Pardon to make a mention, your lordships. Your lordship, sorry, your lordships, I'm not well, I'm appearing on VC. Your lordship, item number 5 of weekly list in this.
Not now, sir. Whenever we call it out. Not now. Yes.
Item number 35.
My lord, in item number 35, I'm there on behalf of Mr. D.K. Mishra, counsel for the opposite party bank, my lord.
All right. None appears to the petitioner. Dismissal orders.
Item number 36.
Memo taken on record. Dismissal orders.
Item number 37.
On behalf of K. Guru, next week. His house.
We're not adjourning it. We're not adjourning it, sir. Proceed with, you have the book.
No.
Dismiss for non-prosecution.
And for
Yes.
the opposite party.
All right.
Item 38.
None appears dismissed.
Item number 39.
Memo taken on record. Dismiss is withdrawn. All the wherever the memos are, you just take it, call out.
Item
Just-
39, 40 and 41. Up to 42.
Yes. We'll
Item
continue.
number 43.
All right. None appears dismissed. Stop. Call out.
ప్రజాస్వామ్యయుతంగా జరుగుతున్నటువంటి పార్లమెంటరీ బద్దంగా రాజ్యాంగబద్ధంగా జరుగుతున్నటువంటి తెలంగాణ ఉద్యమం లోపల
రాజ్యాంగబద్ధంగా జరుగుతున్న ఉద్యమానికి వెన్నుదన్ను నిలవాలని ముందడుగు వేసినాడు. ఏ తెలంగాణ రాష్ట్రం కై ముందుకొచ్చారో కోట్లాది ప్రజల గుండె సప్పుడాయరా. ఉద్యమాల యుద్ధ పేరి సాంబశివుడురో అమ్మా నాన్నలు పెట్టిన పేరు ఐలన్నారా. ఒలిగొండ మండలము సంగం గ్రామంలో నా ప్రజలంతా ఏకమై ధూమ్ధాం సభ పెడితే ఏ అన్న వేదికెక్కితే సప్పట్లు మోగెరో. తెలంగాణ ఎట్లొస్తుందో విప్పి చెప్పెరా. ఉద్యమాల యుద్ధ పేరి సాంబశివుడురో అమ్మా నాన్నలు పెట్టిన పేరు ఐలన్నారా. మీటింగు ముగించుకొని హైదరాబాద్ వెళ్తుంటే గోకారం స్టేజ్ కాడ అంతకముట మాటుగాసే. ఏటా కొడవళ్ళ తోటి మాటుగాసిరో నెత్తురు ముద్దయ్యన్న నేల కొరిగెరా. ఉద్యమాల యుద్ధ పేరి సాంబశివుడురో అమ్మా నాన్నలు పెట్టిన పేరు ఐలన్నారా. బహుజనం పాటలల్లో విప్లవాల పాటలల్లో ఎర్రమట్టి సెలకలల్లో పారేసెల ఏరులల్లో ఏ ఐలన్న ఆశయాల పాటలైతమో ఈ దొరల రాజ్యాన్ని కూలగొడతామో. ఉద్యమాల యుద్ధ పేరి సాంబశివుడురో అమ్మా నాన్నలు పెట్టిన పేరు ఐలన్నారా. ఉద్యమాల తొలి పొత్తువని ఎగిరే ఎర్రని జెండవని భువనగిరి సింధూరమని చెదిరిపోయిన మా చెల్లెవని అలు పెరుగని పాటవే పెళ్లి లలితక్కాని పాటకు ప్రణవిల్లెనే నింగిల ప్రతి చుక్క. అలు పెరుగని పాటవే పెళ్లి లలితక్కాని పాటకు ప్రణవిల్లెనే నింగిల ప్రతి చుక్క. ఉద్యమాల తొలి పొత్తువని ఎగిరే ఎర్రని జెండవని భువనగిరి సింధూరమని చెదిరిపోయిన మా చెల్లెవని. ఊటగడవని ఇంటిల బుట్టిన పులి బిడ్డవు నీవమ్మా. ఆటలాడ పసి ప్రాయం వెతికెను ఆశయాల బాటమ్మా. ప్రశ్నలన్నీ ఒక పాటగా మలిచి మలిచిన పల్లె తల్లి నీవమ్మా కథలు చెప్పుతూ ఎతలు పాడినవు కదనే కోయిలమ్మా కదనే కోయిలమ్మా పాట పైన ప్రతికారము చూపిన పాడులోకమిదిరా పాడులోకమిదిరా 17 ముక్కలై ప్రజల గుండెలో నిలిచిపోయే కదరా నిలిచిపోయే కదరా నీ నెత్తురు దడిసిన నేలన మొలకెత్తిన గొంతై పాడనా అలు పెరుగని పాటవే బెల్లి లలితక్క నీ పాటకు ప్రణవిల్లెనే నింగిల ప్రతి చుక్క అలు పెరుగని పాటవే బెల్లి లలితక్క నీ పాటకు ప్రణవిల్లెనే నింగిల ప్రతి చుక్క ఉద్యమాల తొలిపొత్తువని ఎగిరే ఎర్రని జెండవని భువనగిరి సింధూరమని చెదిరిపోయిన మా చెల్లెవని
Welcome to an episode on Quick Tech Tips. Today I'm going to show you how to remove green screen from a clip in DaVinci Resolve. So to do so, we're first going to get everything onto our timeline. Now we can see I have an overlay of a subscribe clip. I don't want all Welcome to an episode on Quick Tech Tips. Today I'm going to show you how to remove green screen (3D keyer). Then we're going to click, drag and
two boxes over here. One is media in and one is media out. Now what you need to do is click in the media one, and you should use a shortcut called shift plus space on your keyboard, and you will be given a new dialog box with different options. Now what you need to type here is type K keyer. Just copy me.
So can we wait for a few minutes? We'll just run through the weekly list and then start. Or is everybody already there? Oh, it's tomorrow. Oh, I see. Sorry, sir. I made a mistake. All right.
Weekly list item 44.
Can we wait for a few?
May I please, my lord? My lord, in this case, the facts of the petitioner before the learned tribunal is that since he was working as a clerk cum typist since 6/3/93 to 31/5/2009, his services were not regularized, and in the year 2009, his services were dispensed with, my lord. Pursuant to that, he raised an industrial dispute to which one reference made. And my lord, the reference is at, kindly have a glance to page 17.
Yes.
My lord, may I read that?
Yes, please.
Whether the refusal of employment Sri Tara Prasad Bhanja, casual clerk, cum typist by the executive engineer, Rural Works Division, Chandrasekharpur, Bhubaneswar, with effect from 1/6/2009, is legal or justified? If not, to what relief Sri Bhanja is entitled? My lord, during this hearing before the learned tribunal, the second party has examined himself as WW1 and exhibited as 1 to 11. On the other hand, first party has examined 3 witnesses and has exhibited documents which are marked as Exhibit A series, my lord. My lord, what happened during the proceedings before the learned tribunal? The finding by the learned tribunal is that he disbelieved one exhibit which was exhibited as Exhibit 2, in which one list was drawn where it has been shown that the petitioner has worked from since 93 to 2009, my lord. That exhibit has been disbelieved by the learned tribunal. And my lord, that exhibit 2, and during this, during the adjudication, the petitioner also relied upon certain exhibits which he availed through RTI Act, my lord. That is also discussed. My lord, kindly now peruse the documents which are before the learned tribunal. My lord, that is at page 12. My lord, found that page, yes, my lord? Yes. My lord, this is a letter that has been made from Chief Engineer, Rural Work Division, to all executive engineer, my lord. Here it is categorically written as non-finalization of the said list have been viewed otherwise during the course of pre-budget scrutiny meeting. You are requested to please go through the records of the subdivision sections and furnish final list of such category of workers in the said pro forma by 7/1/2003 positively. Executive it may be informed that delay here in the it is categorically written as non-finalization of the said list be recorded in the CCR during the course of pre-budget scrutiny meeting. Thereafter, kindly have a glance to page 11. That is a continuation letters. My lord, that is on 7th January 2003. My lord, found that page, my lord?
Yes, yes.
My lord, in that letter, executive engineer, Rural Work Division, communicated to the assistant executive engineer, Rural Work Subdivision, my lord, that in that letter, it was categorically written to submit the required information by 4/1/2003 with a certificate that personally verified the record and found correct. And my lord, in the last enclosures are 30/12/2002 is enclosed. My lord, thereafter, page 12, page 10. My lord, here also Assistant Engineer Rural Work Subdivision communicated a letter to the executive engineer that the service biodata of DLR, NMR, HR category employees working pertaining to 4 sections under this subdivision is prescribed pro forma for taking decision. My lord, at the bottom, it is received 16/1/2003, 315. The enclosures, my lord, the pro forma. My lord, now what is the pro forma is, which was exhibited to, that is at page 15. Kindly have a glance. My lord, serial number 1. My lord, found that page serial number. That is Tara Prasad Bhanja, the petitioner herein. My lord, at the bottom, it is clearly written, certified the above statement are correct, and in working in subdivision office on daily basis. My lord, there is a counter signature of Junior Engineer, Rural Works Secretary Khurda, Assistant Engineer, Rural Works Subdivision Khurda. My lord, this is the letter which was disbelieved by the learned tribunal. My lord, now kindly have a glance to the finding of the tribunal. My lord, before going to the finding, my lord, I want to place what is the exhibit 2 and 7, 8 and 9. Since he has disbelieved exhibit 2, he has also disbelieved exhibit 8 and 9, which categorically stated that the petitioner has worked during that relevant period. My lord, kindly have a glance to page 22.
Yes.
Exhibit 2 is a statement signed by the junior engineer as well as the assistant engineer of Khurda section, which reflects that the second party working as a clerk cum typist in the subdivisional office and his date of engagement is 6/3/93. Exhibit 8, which is an enclosure of Exhibit 7, is also a statement signed by the junior engineer rural work section, where it is mentioned that second party was engaged in typewriting work in the subdivisional office and his date of first engagement is 6/3/93. And also in Exhibit 9, a gradation list which is signed by the junior engineer rural works, Khurda, the same facts are mentioned. And Exhibit 10, 11 series of the official letters originating from the subdivision office, my lord. My lord, now kindly come to the para 7. Now let the reliability of these documents be examined, explaining as to under what circumstances the name of the second party has appeared in Exhibit 2, a pro forma signed by MW number 2. The witness, management witness number 2, admits to have issued Exhibit 2, but takes the plea that when he prepared the document, he had not verified any office records to get himself confirmed that second party had been actually working since 6/3/93. He has stated that he submitted Exhibit 2 to the assistant engineer merely on an application made by workman. MW2 has further stated that he was posted as junior engineer in the rural work section, such and such, my lord. My lord, on the basis of this, my lord, thereafter kindly have a glance.
No, I think those sentences are important.
My lord?
Continue.
Pardon, my lord?
Continue reading.
Yes, my lord. Conclusion is that
Where she left off.
the vital documents.
Continue reading from where you have left off.
My lord.
Further you read. You continue reading. Don't leave it.
Yes, my lord. He says that, that is, my lord, I stopped here. Workman, MW2 has further stated that he was posted as the junior engineer in the rural work section, Khurda, from September 98 to June 3. He says that during the period, no payment was made to the second party from any funds allotted by the government. According to him, he used to engage the second party as and when required to type out letters, and for the said he used to make payment from his own pockets. As it appears from his testimony, the witness was not attached to the section office prior to 1998. Therefore, when he has prepared Exhibit 2 without verifying any official records, then it can be presumed that information contained in Exhibit 2 is not authentic. when he says that Exhibit 2 was prepared by him, submitted before his assistant engineer, merely on an application made by the second party, it is to be presumed that MW number 2 was officially not required to prepare a statement like Exhibit 2. The second party has obtained the copy of the statement, but he has not obtained the copy of any such document showing the statement marked Exhibit 2 was officially forwarded to the first party executive engineer in due course of official business. Exhibit 2 came into existence on 16/1/2003. The second party claims to have worked continuously since 6/3/93. There is no document on record that originated in between 93 and 2003, showing that second party had actually been working since 93. The second party has exhibited a series of letters marked Exhibit 10 series and 11 series. He has obtained these letters by making an application under the Right to Information Act. He claims, and it is not denied by the other side, that these are the letters which he had typed or written under the instruction of the junior engineer, assistant engineer, Khordha section. These letters are on different dates starting from 1/2/2002 to 25/2/2009. The second party has not exhibited any other letters of similar nature to show that he had written such letters prior to 2002. Thus, there is no material to show that second party was engaged in section office prior to 2002. For all these reasons, it is very difficult to place reliance on Exhibit 2.
What do you have to say to all of this?
My lord, my lord, my humble submission before your lordship is that he entirely disbelieved Exhibit 2. And which has been admittedly prepared by the management witness, my lord, before the learned tribunal. And that was disbelieved. And that was a continuous letter which has been communicated to the subdivisional office with regard to the appointment of the petitioner, my lord. And since he disbelieved Exhibit 2, he disbelieved Exhibit 8 and 9. That is the finding, my lord. My lord, I have shown that exhibit, my lord. It is clearly, my lord, it is countersigned by both the management witness, my lord. Yes. And that has been continuously the communications of letters, my lord.
Did you have any pay slip that you were paid any salary? Normally, these are government establishments, right?
Yes, my lord.
There's no question of receiving payment without a pay slip. Whatever register, some payment register.
That was not executed.
My
lord, but this is the only document which has shown in my favor.
That's the problem.
My lord, because in this, with regard to the veracity of this document, the learned tribunal has failed to come to a conclusion in an illegal way, my lord. Because these are DLR and NMR employees, my lord. My lord, in this way, they
also the very persons who prepared the documents, they were examined, they were not prepared to support those documents.
My lord, they have said that they have prepared this document.
No. The man says, I did not verify any details, and the same man says we used to engage him on work need basis.
My lord,
the same person who prepared the document.
My lord, I bow down, my lord. My lord, but my lord,
that he is paying him from his own pocket.
My lord, can I submit, my lord? My lord, these documents, then how can he forward it to the executive engineer?
So the person who writes those documents is not prepared when he gets into the box to support those documents.
My lord,
you expect the judge to then disbelieve him, the person who's written the document, and he tells the judge, I did not verify before I wrote the document. You are now asking the judge to disbelieve that witness and still rely on the document. This is really extraordinary.
My lord, because this is the document which
but the person who wrote the document is not prepared to support the document.
My lord, because on my representation, since my name was not there, this document was prepared.
That's what transpires, that at your request he prepared a document.
Because
then what does it mean when he tells the court that at his request I prepared the document?
My lord, can I not raise my grievance through this representation since I work?
See, ultimately when you go before a labor court,
yes, my lord,
there is a process of leading evidence, correct? Yes, and you have to prove documents as known in law. How do you prove a document? By examining the author of a document.
Yes, ma'am.
So the author of the document has to say, yes, I prepared this document and this reflects correctly what the position is. Unfortunately for you, the author of the document gets into the box and says, I did not do any verification before I prepared this document. Second, I prepared this document at the behest of this person. Third, he says, no, I engaged him on temporary basis as and when I needed some typing to be done. Fourth, he says, I paid him from my own pocket. And now you're saying, no, this witness should be disbelieved. And the court should somehow say, notwithstanding that the author of the document has abandoned the document is still correct and should be believed. The problem.
My lord, can I pray that this matter may be remanded?
Remanded for what? No. No new witness is going to appear to support it, right? The challenge of the present petition is to an award dated 9th December 2011, passed by the Industrial Tribunal Bhubaneswar in ID case number 9 of 2010, answering the reference against the petitioner workman. Paragraph, the following issue was referred to the tribunal for its decision, reproduced from page 17 bottom. Paragraph, the case of the petitioner workman was that he had been engaged from 6th March 1993 onwards as clerk cum typist under the direct control and supervision of the junior engineer, rural works section, Khurda. Full stop. He's supposed to have worked continuously up to 31st May 2009 without a break. But when he made representations about his name not being included in the gradation list, he was verbally refused employment with effect from 1st June 2009. Stop. He claimed that his retrenchment was contrary to Section 25 capital F of the Industrial Disputes Act 1947. Paragraph. The opposite party management denied having ever engaged the petitioner. Full stop. It was submitted that although the name of the workman did appear in a list submitted by the Rural Works Section Khurda, there was no record in the division office showing that he was ever engaged by the management. Full stop. In the final gradation list of the different subdivisions, the name of the workman did not figure, and he did not file any objection against his non-inclusion. Paragraph. While the workman examined himself as a witness on behalf of the management, MW2, who prepared Exhibit 2, that is a statement of the junior engineer, countersigned by the assistant engineer, reflecting that the workman was engaged as a clerk cum typist in the subdivisional office, was examined. Full stop. Unfortunately for the workman, MW2 stated that he had prepared Exhibit 2 without verifying any office records. Full stop. He further stated that he had forwarded it to the assistant engineer, open quotation, merely on an application made by the workman, unquote. Full stop. MW2 further stated that during the period when he was working as a junior engineer, that is September 1998 to June 2003, open quotation, no payment was made, unquote, to the workmen from the funds allotted by the government. Full stop. According to MW2, he used to engage the workmen, open quotation, as and when required to type out letters. And for that, he used to make payment from his own pocket, unquote. The tribunal, on an appreciation of the above evidence, concluded that Exhibit 2 was not a reliable document. And in any event, there was no other document to show. And that it, full stop, it was noted that it came into existence only on 16th January 2003. There was no document to show that the workman was working continuously from 6th March 1993. Paragraph. Exhibits 8 and 9 have been prepared on the basis of Exhibit 2. Full stop. The evidence of MW3, another junior engineer, who was supposed to have prepared Exhibit 8, showed that no payment was made to the workmen from out of government funds. Full stop. The impressed cash account, bracket Exhibit A series, bracket did not reflect any payment being made to the workman during the entire period of his engagement as claimed by him. That is 6th March 1993 to 1st June 2009. MW3 further stated that Exhibit 9 was not part of any official correspondence, and the facts stated therein, open quotation, were not obtained from any office records, unquote, paragraph. Therefore, unfortunately for the workmen, the authors of the official documents, purported official documents sought to be relied upon by the workmen, was not supported by the authors of those documents. Full stop. The tribunal therefore came to the inevitable conclusion that they could not be relied upon and did not support the case of the workman. Paragraph. Having heard learned counsel for the petitioner, the court is not persuaded that the tribunal has committed any error in holding that the case of the workman did not stand established by the evidence laid before the tribunal. Paragraph. No grounds are made out for interference with the impugned award. The petition is dismissed.
Weekly list item 45.
I am for OP1.
May I please, Lordships? In the present case, the petitioner has grievance that even though he was appointed and completed more than 240 days and has completed continuously 1 year, his service was terminated without following principle of natural justice and by way of a refusal to work. This is my case. My lord, he was appointed as a watchman in a ladies' hostel and continued from 15/7/91 to 10/7/92. He worked continuously. Thereafter, he was denied. And he was given assurance, and a rock sound assurance, that he will appointed as and when will feel necessity or anything of sort. But I come to know that after my departure also they have given appointment to somebody else. But I have been terminated without following the principle of natural justice. Then, my lords, he filed a complaint petition before the conciliation officer, and that ended in a failure, and it was sent to the government. And ID case number 197 of 1990 it was filed, and thereafter the case started. Twice the management remained ex parte. Twice the judgment was expert judgment was passed, and thereafter, and it was allowed, and he approached the honorable court, and it was quashed again. This is last time this present case has been filed. So, my lords, only my grievance is, my lords. Only I pray, my lords, to kindly see my annexure, page 9, annexure 1. Annexure 1, that this is to certify that Sri Pradeep Kumar Dhar, myself, son of Sri Kangai Charan Dhar of village Nihal Prasad, post Nihal Prasad, district in Hekanar, was working as a watchman on monthly contract basis in a ladies hostel of this institution for the period from 15/7/91 to 17/7/92. It has been given by the principal Grama Sevak Talim Kendra, Bhubaneswar. My lords, this is a admitted and undisputed fact that I have worked for 1 year, and that is from 15/7/91 to 17/7/92. Thereafter, they have also given appointment to other things. I will come to my later, my lords. This is the certificate which indicates I was a worker in that organization. Only, my lords, but I have in annexure 2, I have vividly described what has happened to my lords. That is page 10, annexure 2, my lords. That the second party, myself, second party workman has performed continuous service for more than 240 days in the relevant year, which constitute 1 year of a continuous service under section 25B of the ID Act. That the first party management terminated the service of the workman on 17/7/92 arbitrarily without a prior notice or any reason. He has also not been paid the due compensation required under law. In fact, provisions of section 25A of the ID Act 1947 has not been complied with by the management prior to the termination. The workman has performed his uninterrupted duties most satisfactorily and diligently, and there is no stigma during his service career. That neither charge sheet has been framed against him for the misconduct committed by the workman, if any, nor inquiry has been conducted. In effect, principle of natural justice has not been followed before the termination. That suddenly the first party management, out of his whims and fancy, refused the workman employment from 17/7/92, and thereafter he was not allowed to do his duties. The termination of service by way of refusal of employment amounts to retrenchment under section 2 of the ID Act 1947. That it has been stipulated in the aforesaid provision of the law that termination of service of a workman by the employer for the reasons whatsoever, except the exclusion made therein is retrenchment, and it is mandatory on the part of the
Mr. Patnaik,
my lords.
para 8 of the award.
Para
8 of the award.
Para 8 of the order. Para 8, yes. 8. That suddenly on the first party management, out of which whim and fancy, refused the workman
Page
employment.
31.
My lord?
Page 31. Para 8 of the award.
My lords, award.
Page 31.
And come to me. Para 8, my lords. Did we para 8 shall I read? Yes. On a perusal of Exhibit 1, Xerox copy of one experience certificate, it appears that the same was executed by the principal Gram Sevak Talim Kendra, Bhubaneswar, on the 9th November 1996 in favor of the workman. Even if this document Exhibit 1 is accepted in its totality, it only shows that the workman was working on a monthly contract basis as watchman for the ladies hostel of the institution, that is a Grama Sevak Talim Kendra. from this, it appears that Exhibit 1 does not prove itself that the service rendered by the workman was continuous and as defined in section 25B of the Industrial Dispute Act 1947. There is no material on record to show that the workman was in continuous service as defined in section 25B on the Industrial Dispute Act 1947. No doubt, the onus heavily lies on the workman to prove that he was in continuous service as defined in section 25B of the Industrial Dispute Act 1947. In the instant case, except oral evidence of the workman coupled with the experience certificate, Exhibit 1 does not lead to any definite conclusion that the workman had worked under the management for 240 days in the period of 12 calendar preceding to the date of his termination as defined in section 25A of the Industrial Dispute Act 1947. Therefore, it cannot be said the workman is entitled to get the benefits of section 25A of the Industrial Dispute Act 1947. Hence, order the action of the principal Institute of Management of Agricultural Extension, Bhubaneswar, in terminating the service of Sri Pradeep Dhar, watchman.
Para 8 is the conclusion on the basis of the.
My lords, with all respect and courtesy, I would like to submit. I am a watchman. My qualification is not that what is expected, like any other things to appear to be appointed in any other post. There is no such provision that unless one pass matriculation or IR or BA, he will be appointed, and he should have minimum common sense to get something or to extract that he is continuing or continuous service is necessary as per 25A. Has there any document, or could they say any document, or could they produce any document before the court that they had given, they used to give any appointment or any appointee these documents which he does not possess? But what about the principal who has given the document? Have they asked the principal that he has not given, but a first document has been given? Things must be done in the manner it should be done, not in any other manner. So, my lords, that is why natural justice is there, which my lords always says natural justice must be followed. Which Honorable Apex Court hold, natural justice must be there. The fact is, my lords, the fact is that I have worked there and I have completed 1 year, which they have admitted. But now they say in that para that I have not produced any document. What document were there? What document they could show before the court to satisfy that the documents which are necessary, the document which is the...
It is other way around. You have to prove, not they.
Yes, I have to prove. And what I have proved?
You have only produced the experience certificate.
Yes. Have they asked any other documents which I could not prove? I have produced? Or have they say that the rules, regulation, or oral instruction, or many things would prove that these documents are necessary, which he could not show, my lords? I have given oral evidence, my lord, there, and they have accepted it. I have not told lies anywhere else. Now they say, my lords, with all respect, I would like to put a question to myself. What is natural justice? Why they did not take the help of the natural justice? Why they did not produce a single letter to me that you have not worked, or you have neglected, or your conduct, you have borne a misconduct? That is why should your service shall not be terminated? What has prevented them, my lords? Only I want to put this question to myself. And it is my lords who will only be satisfied that the employer has taken all possible steps to see, show, and satisfy that actually he is not fit person to be appointed, my lords. I am coming to my... So that is my lord. They say, my lords, para 7, my lords, I may be permitted to read out. During the course of a hearing, workman, one in his affidavit evidence has stated that he joined in this service under the management as a watchman on the monthly wage of 750 with a effect from the 15th July 1991, and he worked as such till the 17th July 1992, when the management terminated his service by way of oral refusal of further employment. My lords, kindly say, I put a question to myself. By way of oral refusal, what obstructed them to give in writing that your service is terminated because of this, or your service is terminated? No, they will not take any kind of a risk. They know how to extract work, and they know how to harass the poor people like us or like our category. He has further stated that no charge has been framed against him and no inquiry has been conducted prior to the refusal of his employment. And at the same time, he has stated that the management did not issue any prior notice and did not give any notice, pay and a retrenchment compensation before his service was terminated. He has further stated that the management has retained the service of some junior watchman in his place, and he denied the allegations of the plea taken by the management in his written statement. The workman has not filed any document during the course of hearing after the case was remanded to this court by the Honorable High Court of Orissa, Cuttack. But at the same time, on perusal of the case record, it appears that the workman has filed a document, that is one experience certificate, and a proof that the same as Exhibit 1 on the earlier occasion. On the other hand, the management adduced one evidence, Sri Rajkishore Naik, and corroborated the fact stated in his written statement. Nothing has been recited from the mouth of the MW1 to discard his testimony. I am a watchman, nothing more. They are the principal, and the principal has given a certificate that I was working continuously for 1 year. Should it be disbelieved, my lords? Is there any document to disbelieve that certificate given by the principal is wrong, defective, manufactured, or anything of such? So why should he not take into consideration that certificate? It is my prayer, my lords, to kindly consider this one. Therefore, my lords, I do not want to waste my lords' time. Only I would like to say and show simple thing art is held by the Honorable Apex Court and also my lords, that justice is not only be done, but also appears to be done. If my lords says or is satisfied that justice has been done and it appears to be done, I have nothing to say. In addition to this, my lord, the appearance of injustice is a denial of justice. I would like to repeat it. The appearance of injustice is a denial of justice. In this present case, what appears? They have not issued so cause. What has it prevented, my lords? Only I want to get a reply that my lords big reply to that. What is the difficulties for which they could not submit a piece of paper to them that you have committed this mistake? So it clearly indicates it is injustice. So how can I get justice? In addition to this, my lord, the aim and object of natural justice is fair play and fair action. Is it my fair play and fair action? They are employer. They are not educated, but they are highly educated. They are in power, but they have behaved this way, in this manner. So it is not indication of non-application for judicial mind matters. What more a poor man can do it? They said they will call you when we will feel necessary or anything of sort. They did not give me writing, but they terminated my service. Furthermore, my lord, the management has never pointed out that I was irregular or I remained absent without intimation or without any information. Nothing of sort. No allegation of any kind has been shown to satisfy that something is there. minors in page 21 minors. I will give you clear 21 minors. Evidence and affidavit. I am Sri Pradeep Kumar Dhar, myself. I was appointed as a watchman by first party management on 15/7/91 with a consolidated salary of 750 per month, being selected in an interview and posted to perform my duties at Grama Sevak Tamil Kendra under the control and supervision of this management. In course of my employment, I discharged all my duties very sincerely and satisfactorily. And during my tenure
Whatever you have submitted, that has been already there in the evidence.
yes, that I want to say on affidavit has written to me. Neither I have neglected my duty, nor I say I have put forth some false thing before my employer. Nothing of sort. But the learned court below reaches at conclusion, I have not shown or produced any document. What more greater and better document than these, my lords? It is for my lords to consider. Here, may just tell one sentence more. While working as such, when I reported to my duty on 17/7/92, the management verbally told me that the management has decided not to retain my service anymore henceforth, and thereby refused my employment with effect from 18/7/92. The management at the time of termination has neither served any notice nor paid the notice pay in lieu of the notice and any compensation as required under section 25F of the Industrial Act 1947. The management has retained service of some juniors to me in as much as has appointed an outsider or fresher in my place. After being terminated from service, I approached the management and requested for my reinstatement, but my grievances were not redressed. At present, I am unemployed and not gainfully employed anywhere. I pray for reinstatement in my service with service continuity and other consequential benefit. The engagement or appointment was not a contractual appointment for any specific period as alleged by the group. So, my lords, see here, after I gave or informed it, is there any other documents or essential documents or important documents are necessary to reach at the conclusion that natural justice has been followed? Only I put the question myself. Why should the natural justice not be followed? Why have they not followed the natural justice? That should be explained by the management to my lords. So with this I pray, since the injustice has been done, justice should be done, my lords. That is why it has been held by this. Any kind of illegal display of injustice is a denial of justice.
All right, we'll pass the order. Dismissed, we'll pass the detail order. All right.
Item 46.
I beg pardon, my lord. Item number 38, I could not be present.
Afterwards, whenever you call out. Right.
Item 46.
46, I am for the bank.
All right. None appears to the petitioner, dismissed.
Item 47.
47, my lordship, the impugn demand notice under annexes 7 and 8. It covers the corporate insolvency resolution plan, my lordship.
All right. Court is informed that in view of the corporate insolvency resolution plan finalized for the petitioner by the NCLT in proceedings instituted under the Insolvency and Bankruptcy Code, the impugn demands stand covered by the said plan, and therefore no further orders are required in that regard. The petition is disposed of. Both matters.
Item 48.
None appears dismissed.
Item number 49.
OP number 3, my lordship. None appears to the petition, dismissed.
Note 50.
And for the petitioner, your lordship, for the convenience, the second item which was listed, WPC 5180 up to the same may be taken out first.
All right. You can't go to the ombudsman, sir, against the grievance redressal forum.
GRF,
Against the GRF.
my lord.
Don't you have a remedy before the ombudsman?
No, madam. As a licensee, I don't have a remedy before the ombudsman.
I see.
I have prepared a short written note with the date chart. And here, annexure 14, as that annexure 82, annexure 14 as a page 81 is under the challenge, wherein the learned GRF has arrived at the conclusion to treat the consumer as MI consumer.
Who's for the electricity department?
I am for the electricity department petitioner.
Who's for the consumer?
Yes, ma'am, I am happy.
Are you not aware this erroneous bills when somebody goes before the GRF?
Yes.
No appeal is preferable for the ombudsman.
Yes, ombudsman, the consumer can go in
Go, no?
appeal.
Ah.
So GRF has allowed my complaint
Ah.
against which they have referred this request.
I am for the
No, no.
license.
Can they not go before the ombudsman?
No, the regulation and the act only permits the consumer to
I see,
approach,
not the
not the license.
company.
My lord, here, the ombudsman has held that that consumer is GRF has to treat GRF has treated the consumer as MI consumer instead of LI large industry. On this question, my facts arises from the short question. The consumer, while availing the power supply, it was detected that his MD has been exceeded. He was initially drawn power supply on 90 kilowatt, and on inspection it was held from the meter reading that he has exceeded his MD from 90 to 120. That is why the licensee has made a proceeding under Section 126 and also called upon him to execute a fresh agreement for the 120 kilowatt. Instead of, he has also admitted in his reply that due to some reason or other, that same has been exceeded.
Sir, before you continue, what is the date of the impugned order of the GRF?
25/10/2012.
When did, now next question, when did we grant a stay of that order?
Okay, I have. First, I think there is no stay.
Third question, no stay of this order for the last 11 years.
My lord.
Have you implemented this order?
No, my lord. We have not.
Why, sir?
Because he has not complied. On the other hand, he has dismantled his power supply.
So why are you bothered to challenge then? He has not complained. He has not asked for implementation of the impugned order. Why are you aggrieved?
Because there is an order against us.
You are not bothered to implement it. Why are you bothered? For last 11 years, you have never implemented it. Why are you aggrieved? You are very happy, sir. You did not get a stay from us. You never implemented the order. Nobody is complaining. He's also not complaining.
Notice was issued.
So what? Everybody is happy, sir. Why should we suddenly disturb the happiness of everybody? You are happy because you did not implement. He is not unhappy because you did not implement. Why should we add to either your unhappiness or his unhappiness?
Consumer had gone to ombudsman for implementation, but that application was dropped because of pendency of the repeats.
Very good.
And in my counter also I have stated they have almost complied that order by revising the bills. But and it was found that the consumer is entitled to get refund of 33,000 apart from security deposit.
How much refund you'll get? 30,000.
33,000 apart from security deposit of 1 lakh rupees.
All right.
Only because of pendency they have not credited that amount and not refunded.
My lord, your lordship can hear whether a consumer who has enhanced the CD from 190 to 120 and is attracted under 126%.
I have an even more fundamental question of law. Whether a party against whom an order is passed and which order has not been stayed can afford not to implement that order for 11 years? First question.
For that, he, as per my learned friend's submission, he had gone to the ombudsman. When ombudsman had dropped the proceeding due to pendency of this case.
No, you seem to have implemented, sir. You stopped short of implementing fully.
Because he has not paid the assessment at dues and also not executed the agreement till date. Till filing the writ petition, he has not agreed. Your lordship has, I have filed annexed, enclosed the judgment of your lordship, wherein your lordship has held that enhancement of CD is attracted to 126 proceeding, wherein the licensee has done and he has to comply. I have enclosed the judgment of your lordship. So he has bound to pay the 126 assessment dues, and thereafter he has to execute the agreement for 120 kilowatt. He has not done so, and it is his admission. Your lordship can have a glance to the. I may be permitted to read my date chart. Your lordship can have the 11/6/2000 power supply was available. Application for revision of bill. And 10/2/2009 HT meter was installed. 13/11/2009 letter calling upon the consumer to pay rupees 2,08,400 as assessed for the unauthorized enhancement of CD in violation of CD in availing 120 kilowatt as against the approved contract of 90 kilowatt, and further execute a fresh agreement depositing rupees 3,16,080 with a period of 7 days. Reply of the consumer admitting the enhancement of contract demand with explanation. Your lordship kindly have a page 53 of my brief. Page 53. It is his explanation. Page 53. With due respect, I beg to state that we had received a letter that has subjected that we are using unauthorized enhanced the contract demand from 90 kilowatt to 120, but we want to inform you that due to some unavoidable condition for repairing for machinery in the plant with some construction work for the last 3 to 4 months, and also for the failure of the capacitor band, which is out of our knowledge and caused the contract demand had increased suddenly from 7.9 to 10.9. He admits. Hence, we have installed capacitor bank, and from the month of November we are in control. Please, you may keep watch on the same. Gradually, your contract demand will come to the limit by 2 to 3 months as per the agreement of 90 kilowatt. We are now entrepreneur struggling. So he has already admitted that enhanced contract demand has enhanced. So once it is enhanced, the license is bound to call upon him to raise the proceeding under 126, to which he has license has done it, and also called upon to execute the fresh agreement. Instead of availing those things, instead of paying the assessment, he has approached the GRF, and GRF in his order, your lordship kindly have a glance to the order. I have also quoted the relevant findings. Your lordship, 82 page. I am reading out. Para 4, the complainant MS Impacts Ware, KB Complex Station Road, Kotak, is a MI HT consumer with, once it is MI, it cannot be HT. Consumer with a CD 90 kilowatt. It is a consumer since 11/6/2000. The LTT meter was fixed on the LT side of the transformer owned by the complainant. So transformer loss was included in the bill. The complainant objected to the bills from the very beginning. Then HT metering unit was installed on 10/2/2009. Then after consumer grievance for addition of transformer loss was redressed, the OP has committed no mistake adding the transformer loss since it is a MI consumer, and metering has been done at LT side of the transformer before the installation of HT metering unit. Regulation 93(9)(a) empowers the OP for such action. The OP in its submission has stated that from 6/9/2009 observed that complainant is drawing 120 kilowatt of load, which is more than CD 90 kilowatt contracted. Due to such unauthorized enhancements of load, the complainant was assessed under section 126 of the 2003. Though forum has no jurisdiction to adjudicate the matter concerning to 126 of the Act 2003, but unauthorized law leading to change of classification do not attack the provision of the Act for assessment, which shows high-handedness of OP and harassment of the consumer liable to drop to render natural justice. The OP is always at liberty to initiate action under regulation 82 of the 2004 for enhancement leading to change the category. But so long as complainant is in agreement with the licensee to avail supply MI category and agreement is in force, the OP cannot bill it in LI category without terminating the agreement. So how can the when we have called up him to execute a fresh agreement under 120 CD? So how can you terminate and he is availing the power supply? So this finding, unless and until terminated, we cannot enhance the CD or classification. That is totally unwarranted and without the contrary to the provisions of law. So we have demanded and called upon. He has not paid the amount. So this finding and order is totally contrary to the regulations and act. And the consumer GRF, which is a statutory forum, is bound to follow the statutes and as per the provisions of law. Which 126, so also the execution of agreement, of fresh agreement, he has not done. Till filing of the consumer complaint case before the grievance redressal forum. So how can you terminate? And the learned forum below has stated that it is terminated unless until it terminated, it cannot be done. So that question or findings of the learned forum is totally irrelevant and without contrary to the regulations. So this finding has to be done and the order of the GRF has to be set aside.
Sir,
my lord,
you're finished?
Yes.
Challenged by the executive engineer electrical in this writ petition is to an order dated 25th October 2012 passed by the Grievance Redressal Forum, Sesu Katak, in CC case number CDD-2 bracket /424 of 2012 filed by the respondent complainant. Paragraph. At the outset, it requires to be noticed that in terms of the impugned order of the GRFs, the petitioner was to revise the energy bill of the respondent complainant within 15 days of the receipt of the said order. Stop. Although this petition was filed on 5th March 2013, till date there is no interim order passed by this court staying the operation of the impugned order of the GRF. Yet, admittedly, the petitioner has not implemented the said order. Full stop. Paragraph. Counsel for the complainant informs the court that for the non-implementation of the order of the GRF, the complainant did go before the ombudsman, but only because the present writ petition was filed, those proceedings were dropped. Full stop. He further informs the court that the petitioner has in fact prepared the revised bill, but has not acted upon it on account of the pendency of the present writ petition. To stop. In terms of such revised bill, the complainant, according to counsel, would get a refund. Paragraph. One of the grievances pointed out by learned counsel, the petitioner, is that the respondent complainant consumed electricity far in excess of the contracted demand, bracket CD, and also declined to pay the enhanced energy charges.
Assessment charges, my lord. Not enhanced energy charges, assessment charges.
Full stop.
126%.
This led to the complainant being assessed under Section 126 of the Electricity Act 2003. Paragraph. The GRF has noted that An LTTV meter was fixed on the LT side of the transformer owned by the complainant. Full stop. The complainant had objected to the bills right from the beginning. Full stop. As far as the allegation regarding enhancement of the load, it was rightly observed by the GRF that it has no jurisdiction to adjudicate the matters in that regard. Liberty was granted to the present petitioner to initiate action under Regulation 82 of the Electricity Code 2004 for enhancement leading to change of category. Full stop. In other words, the GRF was prepared only to enforce the agreement under which the HT category supply of electricity was made to the complainant. Full stop. It accordingly washed the bills raised by the petitioner by treating the complainant as belonging to the large industrial category. Paragraph. Having heard learned counsel with the petitioner, the court is unable to find any error having been committed by the GRF, particularly since on the specific issue of enhancement of load, liberty was granted to the petitioner to proceed under Regulation 82 of the Code 2004. Full stop. It was further noticed by the GRF that the complainant surrendered its supply on 29th June 2012 itself. And by that time, the initial period of supply was already over. Full stop. There was no occasion for the petitioner to have disconnected electricity supply thereafter on 31st July 2012 or require the complainant to pay any charges after 29 June 2012. Paragraph. For all of the aforementioned reasons, the court finds no grounds
with respect, we have already
with the order of the GRF.
We have already submitted final bill. As that annexure, we have already filed final after the dismantling.
All right, just call out the next. Which is the connected matter, sir? What is the next?
That is also arising out of this present proceeding, connected matter to this.
No, that is not present proceeding. That is a separate complaint filed for petitioner. A consumer made an fresh application for new connection that was rejected on the ground that it is not feasible, which the GRF didn't accept and directed for giving new connection of 25 kilowatt load. That is WPC 6643. That is a separate complaint.
So the connected complaint 6643. You say the earlier matter is 5180. 6643, you say this petition by the executive engineer says so is directed against an order dated 21st January 2013 of the Grievance Redressal Forum, GRF, Cuttack, in CC case number CDD-2/561 of 2012. Full stop. The grievance of the respondent complainant before the GRF was that the petitioner had declined to grant a new connection despite the complainant depositing the requisite fees and despite the officer of the petitioner preparing the feasibility report indicating that it was technically feasible to give a 25 kW connection to the petitioner. Full stop.
Your Lordship, the Lord GRF.
The GRF has, after appreciating the submissions of the present petitioner.
I refer to para
Come
9
to the
of the
conclusion
implement.
that there was no justification for the petitioner to have declined to run connection, particularly when all the required charges were paid by the complainant. Full stop. Having heard learned counsel for the parties, the court is unable to find any error committed by the GRF in directing the petitioner to provide a new electricity connection for 25 kW bracket LT to the respondent complainant. Full stop. No grounds are made out for interference. The writ petitions.
Item 51.
51, my lord, no instruction.
No instructions.
Item number 52.
52, my lord, no instruction.
No instructions dismissed.
Item number 53.
Madam, item 53 on behalf of Mr. Escapade, senior advocate, my lord. He is favoring some ill to
All right, next
pray
matter.
for 1 week after.
Item 54.
Interim order to continue, my lord.
Item 54.
May I please your lordship? The impugned order under Annex 2 and 3 is under challenge before your lordship on the ground solely that without any notice and without any opportunity of hearing to these petitioners, the impugned order have been passed behind their back. Number one. Number two, your lordship, against the dead person in whose favor lease was granted in 1975, who died in 1980. This the impugned order has been passed in 1990. I have prepared a small death chart, your lordship. Of
You're
one
a
page.
subsequent purchaser, or what are you?
We are the purchasers. This
What's
land
the
was,
date of the sale deed?
but this land was leased out in 75.
Sold it date get
Sold it 1986.
And what?
prior to the order.
All right. On the short ground that no notice was issued to the present petitioners who are the subsequent purchasers, who are the prior purchasers, from the original lessee and registered sale deed before passing the impugned order dated 1st February 1986 by the Additional District Magistrate Bhubaneswar, the said order is hereby set aside, and revision case number 508 of 1983 is restored to the file of the AD Bhubaneswar, where it will be listed for hearing on 10th April 2023. To stop on that date, the petitioner will appear along with a downloaded copy of this order. The AD is requested to proceed in the matter afresh and pass a reasoned order within 4 months thereof.
By taking
stop
to the
till
annex-
such time, the interim order passed with this court on 13th January 2014 will continue. What's the next matter?
Now, all these matters that relate to the same case, all purchasers.
All right.
Of
In view of
86.
in view
Same,
of the
same
order
order to
passed
be
in this court today in 22642 of 2013, the impugned orders in these writ petitions are also set aside. And all the corresponding revision cases will now be listed before the AD Bhubaneswar on 10th April 2023, on which date the petitioners will appear along with downloaded copies of this order. The AD Bhubaneswar will proceed afresh in the matters and pass appropriate orders.
Now it is
within a
before
period
your,
of 4 months.
it is before your lordship Tahsildar Bhubaneswar.
No.
ADM has
ADM.
ADM. Obliged.
Revisional authority.
Till such time, status quo shall be maintained. All right.
Item number 55.
My lord, what is the date I have to appear, your lordship?
10th April.
Within 10 days.
10th April.
10th April. Lovely. Urgent copy of it.
Item 55.
Well, item 55, the list shows
my learned senior has filed a counter.
But all right, tell us what the matter is.
Well, here, my appeal has been dismissed on the ground of limitation. My consistent case is, my lord, in any of the proceeding, I was never noticed. When I came to know, I filed an appeal. The appellate court dismisses my appeal, saying that 30 days time was there to file an appeal and you have not filed within 30 days, so it is to be dismissed.
When did you file it? What is the date?
My lord, I filed in the year 2013.
No. What was the extent of delay?
My lord, delay is 26 years.
26 years?
Yes, but my lord, I was never noticed in any proceeding. My lord, no notice was given in the proceeding, in any of the proceeding. I was never noticed. It was completely, I was unaware of anything. And that I have categorically mentioned in my application. My lord, if I am not a party to any of the proceeding, my lord, how will I know about any proceeding being held? Neither my vendor was noticed, nor I was noticed.
You got under registered sale deed?
Yes, I got under registered sale deed.
Who's for the complainants?
Well,
Who's for
my
the
senior-
opposite parties?
3 to 15.
3 to 15.
I am appearing for opposite party 1 to 3.
1, 2, 3 is neither here nor there, sir.
Government, sorry.
No. 1 and 2. 3 to 15 is what we are talking. Have they been served?
3, 4, 5. I am appearing for 3, 4, 5.
3, 4 and 5.
No.
So what do you have to say if he's not made a party? If he's a subsequent purchaser, should he not be heard, sir?
Actually, he is not connected with this land.
Why?
Because original land ex-intermediary.
He's the subsequent purchaser, sir.
My lord, original ex-intermediary has leased out this property to my vendors. And they sold it to me. And 5A proceeding under OEA Act was initiated against the leaseholders.
But he's also a purchaser.
And he says that
Maybe the man sold it to both of you.
My lord, may I submit?
My vendor sold both the parties. My sale was prior, his sale was later, and he got it settled. I filed an appeal that I should be heard.
No. Please,
I was
please.
not heard.
I may be permitted, my lord. My vendor has got 9 acre 92 decimals of land, and he claims 1 acre 35 decimals of land. My case was adjudicated tradeware and on the basis of challenge and deposit of the year 1944 and 1945, I got the lease. His case is that in 1946, he got the lease after the cut-off date, my lord.
Who's in possession?
My lord, I am in possession.
His vendor's vendor.
No, who's in possession?
My lord, I am in possession.
1 minute, sir.
One minute. His vendor's vendor.
Who is in possession, sir?
Possession. Possession, my lord. I am in possession and I have.
See?
And in the settlement proceeding, my lord.
What is my feeling? This is a fit case to relegate the parties to the
That's
civil
what-
court.
That's what.
Because
Both are
there is a
claiming
rival
possession.
claim over in respect of a particular piece
But
of
the
land.
appeal out of my lord, the original proceeding is staring at me. So unless it is said, I've given an opportunity of contesting the appeal, my lord, that will stare at me and civil court cannot have a right to decide this. It can decide possession, but it cannot declare my right because 6-7 proceeding is there in. Again,
Now he says, my lord, he has not been noticed. He has no knowledge. After 26 years, he has knowledge. But in the settlement revision, he was a party. He has engaged lawyer, and he has said that.
Can you make an inquiry and tell us who's in possession?
Lord, this is a private dispute between two.
No, you are very much there, sir.
No,
Ultimately, the orders are all being passed by your officials.
As a authority,
Find
judicial
out who's in
authority.
possession. Maybe neither is in possession and somebody else is in possession. Today we pass an order. Somebody will come tomorrow and say, no, these two gentlemen have sold it to us.
Again, another.
It's very likely.
Moreover,
These are all Bhubaneswar or Bhadrak, isn't it?
No, it is not Bhubaneswar.
All right.
Had it
You
been
never
in
know.
Bhubaneswar, I would have.
so many persons
You
have
never know
dead.
who's in possession, who's got.
After that, my lord, some persons have been dead at the opposite party. No substitution has been taken. And the some other person, those who say that they are the necessary parties, they have not been made parties.
All right. Both the petitioner as well as respondents 3, 4, and 5, opposite parties 3, 4, and 5, claim that they are the lawful purchasers of the property at, where is it located? Plot number? No, in Moza Gailpur, under Tauzi number 1547 of an Anabadi Khata number 658, plot number 1966, acre 9.92 decimal. And that each of, and in fact, and that each is in possession. Full stop. These claims are obviously at cross purposes. Full stop. The court would require the
Tahsildar to
Tahsildar Madhav Nagar. What is this?
Bhadrak.
Bhadrak. Additional Tahsildar Bhadrak, or this Tahsildar Bhadrak,
Tahsildar.
to conduct an inquiry by personally visiting the site and submitting a report to this court as to who's in possession, and in the official records who's shown as the owner of the property in question. This report be submitted before the next date, list in the regular bench, in the regular list, whatever, on July 5th. Interim orders to continue.
Obliged. Item number 56.
56, my lord, no instruction.
No instructions dismissed.
Item number 57.
Yes, my lord. I mean, permit to withdraw with liberty to file appeal provision there. OGLS Act.
All right. Counsel, the petitioner seeks leave to withdraw the present petition, liberty to file an appeal against the impugned order. In terms of the OGLS Act, this post office withdrawn with liberty is prayed for. The appeal is filed not later than 3rd April, accompanied by an application for condonation of delay, explaining the pendency of the present petition as the reason for the delay. The appellate authority will consider it in accordance with law. The court clarifies it has not expressed any view in the matter. If the appeal is filed within the time stipulated, accompanied by an application for interim relief, then till such time an order is passed thereon by the appellate authority, the interim order passed by this court on 10th April 2014 will continue. The petition is disposed of, is withdrawn with liberty is prayed for in the above terms.
Item number 58. It I am the opposing party.
None appears to the petitioner. Dismissed.
For the petitioner. My lord, actually, Vesco has been taken over by Tata Power right now. So due to the change in management, we have not been able to take instruction as per the present. So
we'll just say that no instructions dismissed. As and when you get instructions, you revive it. All right.
Item 59.
In item number, no instructions.
No instructions.
60 is, my lord, covered by that ASO's orders, my lord.
Narottam Brata. 60 Narottam Brata.
Much of that.
Kota Narottama, 60.
Item 61.
my lord, this matter is infructuous.
Dismissed as infructuous.
Item 62.
My lord, item number 62, my lord. As in the meantime, my lord, the retrenched workman has been re-engaged through outsource on contractual basis, and they are continuing till date. As to which, my lord, section 25F is not applicable and the matter has become infructuous.
All right. It is stated that the matter has become infructuous. It is disposed of.
My lord, that may be recorded, my lord. They are still continuing.
Not,
All
we
right.
just say you're saying it is infructuous. That is enough. Oh, yes.
My lord, at least liberty may be granted to file fresh cause of action if.
That no need for liberty, madam. Yes.
Item number 63.
None appears dismissed.
Item number 64.
May I please the law? My lord, the petitioner challenged the order at 27/12/2012, my lord, against the order passed by the Law and Labour Code, my lord, Jaipur, my lord, in which the retirement benefit, my lord, that about rupees 2,73,512 has not been given to the concerned petitioner, and the prayer of the petitioner is rejected by the Foreign Labour Court, my lord. That is Annex 2, my lord.
Was there an award? Prior to this 33C2, was there an award, sir?
No. That is when the retirement benefit, my lord. After.
There must be a determination, sir. Only then 33C2 will come in.
My lord, actually, after retirement, my lord, he had, that is.
So you must raise a dispute, you must get an award. Then for implementing that award, you can go under 33C2. Without determination of that dispute, you can't invoke 33C2 directly, sir. That's the law. It appears that the workman has filed the present petition challenging an order dated 27 December 2012 of the Labour Court, Jaipur, rejecting the petitioner's application being industrial dispute miss case number 9 of 2010, filed under section 33 capital C bracket 2 of the Industrial Disputes Act 1947 bracket ID Act. Paragraph, after his retirement from the Respond 1 OFDC Limited, the petitioner filed the above application for a sum of rupees 259,935 towards ex gratia and leave encashment. Full stop. The fact of the matter was that there is no prior determination whether the petitioner was entitled to the above amount by means of a separate award of the Labour Court. Full stop. Therefore, it was doubtful whether an application straightaway raising such a claim could be maintained under section 33 capital C bracket 2 of the ID Act. Paragraph. Nevertheless, even on otherwise, the Labour Court has found that disciplinary proceedings had been initiated against the petitioner for causing financial loss to the tune of rupees 428,038 and a penalty for recovery of 437,237 was imposed on the petitioner by an order dated 26th April 2007. Stop. This was not disputed by the workman. Stop. Procedure for recovery was already initiated against the workman. Stop. It was rightly observed that those proceedings could not have been challenged by the workman in proceedings under section 33 capital C bracket 2 of the ID Act. Paragraph. Having heard learned counsel for the petitioner and having perused the impugn order of the Labour Court, the court is unable to find any ground to interfere with the said order. The writ petition is accordingly dismissed.
Item 65.
None appears dismissed.
Item number 66.
May I please? My lord, that is covered by Narottam Nath case, my lord. That is the order of settlement option.
66.
All right. All right.
Item 67.
67.
Lord, the grievance, Lord, total boils down to the issue as to payment of ID cost, infrastructural development cost. Here, your Lordship will find I have a small list of dates and friend is giving to your Lordship. Yes. Petitioner's husband was an applicant for a plot in the GA under GA department. By the time allotment was made, the husband was dead. At page 11, Lordship would kindly see the allotment order. Though it is the name of the petitioner, husband, but the husband was no more there. But allotment order applied in the year 1981, allotment in the year 1992.
New capital Bhubaneswar.
New capital.
So what is the value today?
Lord, I'm not disputing the value. Lord, I am on some other point. Your Lordship will kindly see what is the issue here.
First of all, are you in possession or you're not in possession?
But they have not given me because of the non-deposit of IT cost. They have not given me.
Okay.
Lord, the issue,
and you got an interim order here.
Lord, I got an interim order. Lord, I only say, Lord, my limited prayer before your Lordship would be, Lord.
Yes.
The manner of calculation of the ID cost so far as the defaulters are concerned, that is completely, Lord, irrational. That your Lordship, I can so demonstrate to your Lordship, Lord. I can demonstrate that. And in that view of the matter, I am not asking your Lordship to calculate that. Lord, I'll obviously seek a liberty from your Lordship to approach them to recalculate it. And till that date, let the protection be there.
That's a good point, sir.
That otherwise, not my value of the right goes away.
One factual submission. My lords, this petition, my lords, this is the second round litigation. Now, my lords, the first round litigation.
Can I just, before my land friend, can I just explain that from my side? Let your Lordship see, my Lord, what is the issue here. Now, they allotted me in the year 1992. My husband was dead. I applied for mutation. Lord, on the issue of legal heir certificate, they rejected, they did not allow my mutation. I came before your Lordship, my Lord. This Honorable Court dismissed my writ petition. Kindly turn to page 35, my Lord. This Honorable Court dismissed my writ petition, saying that this legal heir issue and other issues, kindly see page 35, order is there. This Honorable Court dismissed my writ petition, saying, same Lord, the documents do not disclose material fact. After receiving those facts, they will take steps, but the petitioner has not taken steps. After receiving the said information, 2 years thereafter, the petitioner have come up with the present petition seeking relief as aforesaid, petitioner residing in West Bengal, so they, without complying with the terms and conditions as stipulated in the allotment order, have approached this court at a belated stage. Therefore, we are not inclined to entertain the writ petition. Dismissed. It is dismissed, man. Now, thereafter, the GA department show motto, just flip over the next page, page 36. Just flip over the next page. Page 36, 2014. GA department themselves mutated the land in our name. So my cause of action arose afresh pursuant to their own action. 2014, they allowed mutation in my favor, accepting my legal heir status. Kindly similar page 36. So dismissal of the writ petition will will obstruct on my way to get my rights settled with them. Page 36, kindly similar. They mutated it in my name, Aloka Gupta, the present petitioner, son so and so. This is 2014 after dismissal of the writ petition. Now, kindly similar in the year 2013, they themselves revised their guideline. Lord, I am asking benefit of this revised guideline only. Kindly see, my Lord. Page 39, para 6. Just this paragraph I'll show, my Lord, nothing more.
But I don't know how you did not avail of this. What is the extent of, what is the size of the plot?
Lord, size of...
it is
60 to 90, no?
60 by 90. 5,400 square.
Wow.
No, Lord, I'll tell you, Lord, see, the premium I have paid, entire premium I have paid, they have received.
It's 2.5 crores.
No, Lord. Premium at the cost that they demanded from me, Lord, in terms of the allotment order, kindly see page 11, 55,786.
So
that I paid within the time stipulated, man. So that's paid.
That's 32 years ago, sir.
But they are not, Lord, after they have accepted the premium from me, my Lord, kindly consider, my Lord, I have their term of their lease deed condition is after they execute the lease deed, I am supposed to pay the ID cost.
Yes.
Lord, I have paid the premium to them.
Yes.
They have accepted the premium from me, my Lord.
Yes.
And thereafter only they will execute the lease deed.
Yes.
And I am supposed to pay the ID cost.
Yes.
Now your Lordship see the receipt I have said. Yes. Lord, I have paid the entire premium to them within this period of 120 days. One just clause your Lordship may kindly see that the 2013 revised guideline, my Lord. I am coming out of that only. Kindly similar page 39.
Yes.
Clause 6. This is the only clause I will show, my Lord, and I request your Lordship to consider this, my Lord.
Yes.
For cases where allotment orders have been issued,
yes,
full premium has been paid within 120 days, which I have done. from the date of issue of allotment order, lease deed formats have been supplied for execution, but the allottees have expired. Not my allottee has expired without executing the lease deed, and legal heirs now want to execute the lease deed. The legal heirs, successors of the allottees shall be allowed to execute the lease deed by cut-off date, that is by 31st of March 2014, on deposit of differential premium at the prevailing rate and revised ID cost at 2.5 crore per acre in one installment within 90 days from the date of information, failing which allotment shall automatically stand cancelled.
Yes.
Now, my lord, I am ready and willing to comply with this term. I have paid the premium in full. My lord, only just see, my lord, the manner of their calculation, my lord, what they have done.
Yes.
Page 48, my lord. Page 48, the way they are demanding ID cost from me.
Yes.
My lord, they have an allottee of, kindly see, my lord, they have allottees total
Mr.
of...
Ratha, I don't know what your financial capacity of your clients are, but it's a gold mine, sir. It's a gold mine.
Lord, may I pray, my lord? Lordship may permit
better
me...
to stay off than if you're not able to afford this for a Bhubaneswar plot. Don't aspire for it.
Lord, may I request, my lord? Your lordship may permit me, I'll approach them to work
But
out.
no interim order, sir.
Lord, they will allot it in favor of some other person, my lord. But then in that case, Lord, your lordship may give a 1 month time to them. Lord, let it be just Lord, calculated. Whatever comes out of that.
It will be much more, sir, now.
No,
may I make
in 2013, you are required to pay 2.5 crores per acre. Now it will be much more.
Lord, only your lordship may permit me. I'll raise this issue before them. Lord, let them recalculate. I say that this is, my lord, unconscionable. Because the whole expenditure they have incurred towards ID cost of 2,700 allottee, they are now realizing from us.
This whole litigation is speculative, sir.
But I can understand, my lord. Your lordship may see, if they would be rational enough, kindly see, my lord. Lord, they have total allottee of 2,700. Lord, their own calculation, kindly see, my lord, what they have done. Page 48, what they are doing is 2,700 allottee. There are defaulter of 200 numbers defaulters out of them. They are realizing the whole ID cost of 2,700 allottees from these defaulters, 200 people. That is what they are doing, my lord. That is how the ID cost has increased. Otherwise, my lord, it will at best come 20 lakhs per acre. Now they are charging 2 crores per acre. In this manner, they have done page 48 manner. So that's the reason, my lord, Lordship may allow me to, my lord, raise my grievance before the government, my lord. I'll raise all these issues before them. Let them at least take a conscious decision on my grievance, man.
No, sir, not inclined. You say the challenge, the present petition.
My lords may see my counter affidavit, which I find.
Dismissing.
Lord, may I suggest?
If you want to say something more, we'll pay.
Lord, may I suggest, my lord? May I suggest?
Just,
Lord, I'll pay the demanded amount, man. Lord, I'll pay, Lord. I'll abide.
My lords, that is why, my lords, I was pointing out my counter affidavit, because in our counter affidavit, we say that the letter, the 42 lakh letter was inadvertently.
He's not paying that amount. He says whatever is due as of today.
I'll pay.
No, my lords, he's not, because that policy, my lords, it says that in 120 days, my lords, you have to do certain things. He hasn't done it, so he will not even get the benefit. And therefore, my lords, my lords, also the single previous litigation, there was a particular declaration to be given that this person should be a permanent resident of Orissa. That, my lords, is not there because they have been staying in West Bengal. So as per, my lords, the allotment rules, my lords, they are ineligible.
I see.
My lords, that, my lords, will file at page 34, my lords, of the order.
I see.
Not a permanent resident, 5 years residence period.
It says he's a permanent resident of Orissa and has resided.
I'll pay. Let them.
But it's not just about payment, sir.
These are ineligibilities.
But 2014, they have themselves muted it. Kindly see, man. They have corrected my name in the records. Kindly see, page 36. But this proposition is not available to the state. They have done it, already allowed in my favor. Kindly see page 36,
But it's strange that after that you were still asking them to deposit 42 lakhs.
We have said that, and we have tendered unconditional apology for sending.
You are the ones who gave them hope. And then you accepted the mutation, you granted that also.
Yes.
All right. All right. The writ petition is dismissed. We pass the detailed order. Dismissed.
Item 68. Item number 68.
If I may please your lordship, I'm appearing on behalf of my learned senior, Mr. Bhuya. Your lordship, we have entered appearance as the petitioners as well. Lordship, this case pertains to a property which is claimed by us to be a private walk-off property. Lordship, under the section 3 of the Act, and we are claiming to be the successors of the said Peer Syed Kalandar Badshah.
Who's for your opposite parties, sir? 3 and 4? Who's appearing for them?
3 and 4, your lordship.
3, no, not just 3 and 4, no? Yeah, 3 and 4. No. Large number of opposite parties. 3 to 13. Who's appearing for 3 to 13? And then Waqf board also has to be heard, right? Oh, where is he?
Opposite
Mohammed
partner,
Azad.
2 is the contesting party. 2.
Let it stay on board, so let them come. Without hearing them, can't decide this matter.
Much obliged.
Item 69.
I may be permitted to place it on behalf of Mr. Mohanty, on Ms. Mohanty. Well, a piece of land of which I am owner and the record of right published in 1977, a portion of which has been encroached by the for construction of road and block. Now, I filed a suit in the year 2004. Pending that suit, the Tahsildar called upon for negotiation, and they negotiated to exchange a portion of government land which is adjacent to my land in lieu of this property which they are using, portion of the land they are using. So accordingly, a joint inquiry was conducted. Your lordship kindly come to page 13. In view of the positions, the owner of the private.
No, but what happened to that other land now? By now
that is exactly that. So the exchange case continued, and in turn it is submitted to the collector and then to Revenue Divisional Commission. These are being recommended in my favor to the government. Now pending that.
No, for exchange, you're exchanging some other plot for this, correct?
The mine land, they are taking the road. And
what are they giving you in exchange?
The Gochor land. That's so that is
the road has already come up in our land.
Yes, my lord.
There was some status quo order. How come?
No, my lord, it is prior to that. They have all fast done. Then I went to the civil suit, and pending that civil suit, they accepted the exchange proposal. They constructed it. Then
this is already infructuous.
No, they are the exchange case. What is my case is that the portion of land in any event in my land, if they are using, they have to pay me the compensation, or in lieu of that, they have to give the exchange land.
No, exchange land you already have, you say?
No, my lord. The exchange land was the proceeding was initiated. This proceeding has come to the up to the level of RDC with all recommendations.
No, when this court passed an order 18/8/2014, status quo as on today over possession of the petitioner in respect to the land in question be maintained. What does it mean then?
That is that the exchange land they have given possession.
So you are in possession
of that land, yes.
Let's get the facts clear. So the exchanged land has been given to you, you're in possession, but you simply want ROR to be changed.
Yes, madam.
You apply for that.
No, madam, that they are not finalizing the proceeding. That is what the issue.
There's a slight issue here, Millards. In a counter affidavit, Millards, the issue is that he had that land, and thereafter, Millards, 1977, Millards, there was a settlement, and we found out that actually in that settlement he had fraudulently introduced his name in the records, and it was actually in possession of a person named Bhagavata. I'll just read the name. And then OEA proceedings were there, and he was the ex-intermediary. He had given that land.
So whatever it is, you pass final orders. That's it. Whatever you have to pass final orders. If you have to deny him, pass final order and be done with it.
If they deny me, insofar as my land is concerned, they have to pay me compensation.
He just says you pass final orders. Why are you keeping the matter pending?
And if they deny now, they're in the counter denying me to grant me the exchange, then they have to pay me the compensation. Now in 2000,
no, they'll pay whoever is the owner of the land.
No, I am the owner. That is not.
That we don't know because he's disputing that also.
Yes,
no, that they dispute. 1977, the RO has published.
All we can say at this stage, because we've seen the prayer, you only want the proceedings to be finalized.
Ex parte, I can show your lordship that is 1 year period is the limitation given under the act. That is filed 1977 is the ROR has been published.
Anyway,
in 2012 they filed.
Yeah, only grievance in the present petition is for a direction to opposite parties 1 and 2 open quotation to take a final decision in exchange case number 8 of 2008. And court considering the proposal submitted by the RDC CD Cuttack. Paragraph. While directing notice in the present petition on August 2014, this court directed status quo to be maintained as regards possession of the petitioner in respect of the land in question. Paragraph. It is accordingly directed that if no final order has yet been passed by OP number 1 in regard to the aforementioned exchange case, then such order shall be passed positively on or before 1st May 2023 and be communicated to the petitioner within a week thereafter. Full stop. Till such time the interim order passed by this court will continue. Stop. If the petitioner is agreed by such order, we open to the petitioner to seek appropriate remedies in accordance with it. The court clarifies it has not expressed any view in the matter.
Item number 70.
If I may be pardoned, your lordship, item 68 interim order may be extended.
They're not passing the orders, it's just on board. Yes.
Item 70.
I'm sorry, your lordship.
None appears dismissed. Both matters.
Item 71.
Well, this is covered by your lordship's judgment in Narottam Rath case.
All right. Narottam.
Item 72.
In fact, the grievance is with regard to non-payment of compensation. The OP number 2 is dead. I have filed one interim application that is at flag A, my lord, with regard to making a prayer for impletion of parties. But then yesterday my instruction was that they are trying to compromise, settle the matter among themselves. So either your lordship may dispose of the matter saying that the parties are.
All right. Mr. Rathe points out that as regards the grievance made in the present petition, the parties are
exploring the
possibility of settling it inter se amongst themselves. The parties, that is the petitioner and opposite party number 2 and the legal heirs of opposite party number 2 are seeking to settle the matter amongst themselves. In that view of the matter, the court is not inclined to pass any orders at this stage. The petition is disposed of.
Right. Item 73.
I am for the appointed demand, my lord.
None appears to the petitioner dismissed.
Item 74.
24, my lord, I am for the opposite party. Counter not filed, my lord.
My lordship, they need to file a counter, my lordship.
No. What's the matter about?
My lordship, actually, we have challenged the order of the learned court below, my lordship. My lordship, kindly have a glance to the order, page number 26, my lordship. My lordship, the issue was that whether the fixation of the scale of the pay of rupees 2,774 to 4,724 for the dispatcher with effect from 1/4/97 by the management of RHEP OHPC Rengali White order number 11405. And the finding is, my lordship, to issue number 1 is, my lordship, in the case the second party union claims the scale of the pay of rupees 3,600 to 6,550 for the post of diarist cum dispatcher under the OHPC with effect from 1/4/1997 instead of the pay scale of 2,770 to 4,724. Admittedly, the Balimala hydroelectric project is providing the scale of the pay of rupees 3,600 to 6,550 to its dispatcher. But here, my lordship, the learned court below has not given the detail of the order because, my lordship, in our written notes of submission, which we have filed as Annexure 1, my lordship, we have written that after the OHPC formed, my lordship, he has his own rules and regulation. And as per the rules and regulation, my lordship, we have all the category of the people, like any 1, any 2, and any 3, 4, 5, like this. My lordship, these people are the diarists and they are for the any 3 category. So their fixation of the pay is, my lordship, uh, 2,770 to 4,724. Because, my lordship, after they come from the government, my lordship, what they are getting much higher from the OHPC, my lordship. That's why, my lordship, the learned tribunal has not given in his finding the detail of the order and only just pass the award that though in the second party union claims the scale of pay 3,600 to 6.
I think the ground is just come to page 30.
Yes, my lordship.
This Balimela hydroelectric project is also your project, right?
Yes, my lordship. Our project.
There, in that project, you are giving the higher pay scale to dispatchers.
My lordship, they are any 5 grade, my lordship, because under the government they are working in a higher pay scale, so they are getting 3,600. But these people are this union have filed particular for 1 person, my lordship, and he is getting, my lordship. I have already annexed, my lordship, and my lordship, kindly have a glance to page number 21.
Only 1 person. You're fighting this 1 person's salary.
My lordship, the union has filed for the 1 person, my lordship. Yes, my lordship.
Why should you contest this 1 person's salary?
Because, my lordship, what
will happen? Nothing.
What happened? There is only 1, my lordship, 1 post is vacant for the dispatcher, any 3, my lordship. And my lordship, another thing is they have come before this honorable court, and honorable court has given the direction to file a representation before the authority, and they have already disposed of the representation. They have never challenged that representation, and now they filed before the labor court, my lordship, for the higher pay scale.
Rejection of representation doesn't mean that they cannot challenge.
Yes, my lordship, they can challenge, but it cannot go beyond the rule and regulation which.
And this "they" is a problem. There's only 1 person.
But, my lordship,
we're only talking of 1 person.
Yes, my lordship, but my lordship, kindly have a glance to page number 21.
What is that age of that 1 person, sir?
My lord,
you are representing that 1 person.
My lord, that the union peoples of the post of dispatcher. My lord, the fact is like this, my lord.
1 minute, sir. Why don't you answer the question?
My lord.
She's talking of only 1 dispatcher whose cause you're espousing.
My lord.
That 1 dispatcher, what is his age today?
Age of the employees, my lord.
If you say dispatcher.
I can repeat.
My lord, may I respond submission?
Age of the employee.
Age of the employee now they are continuing, my lord. There's more than 55, 56.
That only diarist.
My lord.
What would be his age now?
60 years, man. 60 years, so that is retirement age.
So why do you want to pursue all this? We'll leave the question open.
My lord, the background is, my lord.
1 minute, sir. We are trying to pass an order in your favor. If you're going to stop us from passing an order in your favor, I don't know what advocacy this is. We want to dismiss her petition. And you still want to argue, sir?
No.
My lordship, kindly have a glance, 1 minute glance for page number 21.
60 years old, and this is 1 employee. We leave the question open. In some future case, you can take it up. All right.
My
You say
lordship,
the
they
challenge
will
in the present petition is to an award date.
demand from 97, my lordship.
Sorry,
1997, my lordship, they will demand
what?
that pay scale, my lordship.
Madam, this plural singular is your problem. Same problem for him. One, according to him, is many employees.
No,
For
one
you,
employee.
one means they.
Sorry.
So, my English gets very seriously questioned. Sometimes I begin wondering whether I have to go and relearn my English.
Page 27 is your answer.
21, my lordship.
27, the question.
The challenge in the present petition.
Yes, my lordship. That the answer, my lordship, we have written.
Only dispatcher, that's all.
Only dispatcher. And in page number 21, we have already clarified how much that person was getting from the government and how much we are giving him.
Anyway, all right. The challenge in the present petition is to an award dated 21st March 2014, passed by the Industrial Tribunal in Bhubaneswar in Industrial Dispute Case number 3 of 2014, answering the reference made to it in favor of the workman and against the management. Paragraph. The following reference was made to the tribunal for its determination. Take from page 27, top paragraph. On formation of the Orissa Hydro Power Corporation Limited (OHPC), the Ringali Hydroelectric Project, which was earlier directly controlled by the state government, came within the administrative control of the OHPC. Along with it, the Balimela Hydroelectric Project, which was under the control of Orissa State Electricity Board, also came within the control of the OHPC. Paragraph. The present case concerned the pay scale payable to the single quotes dispatcher, unquote, employed in the Ringali Hydroelectric Project. Good stop. His claim was that there should be a parity of the pay scale given to the dispatcher of the Balimala Hydroelectric Project. Which was rupees 3,600-6550. Full stop. The case of the workman dispatcher was espoused by the OHPC Employees Union, bracket, opposite party number 2, bracket. The case of the OHPC was that prior to absorption of the RHEP, there were 2 separate scales. That is NE2 and NE3. Stop. As far as the dispatcher in the present case working in the RHEP is concerned, since he was drawing the NE2 grade scale in the government, it was contended that he was not entitled to parity of pay scale with dispatcher engaged in the Balimela Hydroelectric Project. Paragraph. The Labour Court appears to have rejected the above plea by observing that for the same scale, for the same post of dispatcher in 2 different units of the OHPC, there cannot be 2 different pay scales after the units were absorbed in the OHPC. paragraph. Apart from the fact that this is a plausible view to take, the court finds that during the pendency of the present petition, the diarist cum dispatcher in question is near the age of superannuation. And it is an individual case of one person, since admittedly there is a single post of dispatcher. Paragraph. In the circumstances, while clarifying that the impune award of the industrial tribunal will not constitute a precedent for any similar claims in future, the court is not inclined to interfere with the impune award. Stop. Interim orders vacated, the petition is disposed.
Item 75.
My lordship, 75 is also same matter, but here the person is Pharaoh printer. He is also my lordship from
Single
NDC.
person.
Yeah.
All right. Same order. We just have to change the post. All right.
Item number 76.
Lordship, 76, no instruction.
No instructions.
Item number 77.
My lord, Mr. Rath is on his legs. Let it be on board.
Right.
Item 78.
May I pledge your lordship, my lord? The matter relates to my lord. The OPLE proceeding has been initiated against the petitioner, my lord, and the revision has been dismissed by the RDC, a collector, my lord. My lord may kindly see the annexure 5 at page, my lord, at page 48. It is the land situates in the township of Sambalpur, my lord. My lord may kindly look at the annexure 5, page 48. May I place, my lord? It has come to the notice of the Department of Tahsildars are initiating eviction cases under the provisions of Orissa Prevention of Land Encroachment Act 1972 for eviction of encroachers from public premises as defined under the Orissa Public Premises Eviction of Unauthorized Occupants Act 1972. The matter was examined in concerned law department. The word public premises has been defined under Section 2F of OPP-EUO Act, which means any premises situated within the jurisdiction of municipal council or NSC or within an area declared by the state government to be an industrial estate and belong to or taken on lease by the state government, etc. As per Section 2 of the above Act, premises means any land or any building or any part of
this order of the collectors. You can't go further in appeal, is it? Under the
No.
OPLE Act.
No, we have already gone in revision. That is
Revision. He is coming against the revision.
Beyond that,
RDC.
RDC.
Oh, I see.
So here the OPP-EUO case
Where is
has
the
been
RDC's
initiated by the authority, but it is not been initiated. So they have started OPLE case. We challenged it on the ground of this plea also, but they rejected it.
Where is the RDC's order, sir?
Annexure 3, my lord.
Annexure 3 is the collector's order, sir.
No, the collector is the revisional authority, my lord.
Sorry?
Collector is the revisional authority, my lord, in this OPLE proceeding.
No, against that, there's no further.
No further, my lord. Read this, my lord.
Yes, this is revisional. Revisional authority.
Revisional authority, my lord.
Page 34.
So already it went back. But earlier the RDC Sambalpur was asked to rehear the appeal.
Rehear the appeal, my lord. After rehearing only this has been heard. And thereafter, we challenged the order which the claims were not considered by the authority. In High Court, my lord, thereafter this Honorable Court directed that eviction proceeding be initiated against us, without considering that our 55 years of possession over the said land from the lessee, my lord. It's a leasehold land. The case, my lord, is like this, my lord. The case land was, my lord, the third generation lessee Jogendranath Sen, my lord. My lord, he became the member of Johnson, and the Johnson office was started there, my lord, in 1967.
May I submit one thing?
My lord, May I submit? May I submit thereafter, my lord? My lord, thereafter, my lord, he died. Thereafter, her wife and daughter were the they belonging to party of Johnson, and they continued, my lord. In the year 1986, my lord, and by that time, my lord, they wanted to transfer the land to the BJP office, my lord.
No. Who wanted to transfer the land?
The Shobha and the Sandhya Sen and Shobha Chakrabarti.
No. So is there a document of transfer?
My lord, which document? Transfer? No. My lord, they asked the collector, he was the approving authority, said that it may be transferred to Jansang office because the other approaches.
Ask meaning what? They gave a letter or what?
They have given the letter in the 1960s, my lord.
Where is that letter, sir? Show us a copy.
We don't have, my lord. We don't have the Sen and Shobha letter, my lord.
Is there a document of transfer?
Collector said that we have to file the lease application for the land, my lord.
No, but unless you show a letter, sir, unless you show that letter of 1963, where do you get a locus to file an application?
No, my lord. We filed the legislation in the lease application, my lord, separately.
On what is the locus to file it?
My lord, we are in possession, and two ladies, my lord.
That's the whole question, sir. This is exactly the point here.
My lord,
question.
My lord, let us have a pause, my lord. Thereafter, my lord, what happened? After that, 1986. The collector took the vacant land, and thereafter, the next day, 1986, 50 decimals of land, and we are occupying only 60 decimals of land. Thereafter, the collector, 21/7/1986, recommended the case lease renewal in favor of Shobha and
1 minute, sir. 1 minute.
May I submit one thing to
You better examine if you can regularize this.
No, one thing I mean.
If there been occupation since 86.
High Court, pursuant to the order of the Honorable High Court, the proceeding was initiated under the OPLA Act. Admittedly, it is in the Anavadi Khata, recorded owner is the government. Now he is saying by virtue of certain documents, that is 1966
No, he doesn't have the document.
No, that is what I am saying, that we have got subsisting right over the property in question. So, if your lordship can relegate them to
Annexure 2 and Annexure 1,
because it is a case where they claim that we have got title over the property, which cannot be decided in a OPLA proceeding. OPLA proceeding, it is very confined to the record of right, and
P number 4 is the successor of the original lessees.
And that is what I am saying.
OPLA case cannot be continuable.
Apparently, you are very magnanimous, sir. You very happily gave it to the party. That's what they say.
No.
Yes.
It has not been
You have a very large heart. That's what
Sir,
Hota is
it
saying.
has not been given.
You're very large-hearted. You gave it to us, he says. In fact, he gave it to the Jansang, he says. In 1963 itself, no, sir?
Well, in 1967.
So
that
your large-heartedness goes back 50 years.
Like that. Second matter.
For a very noble cause. For a very noble cause.
Your lordship can take up the second matter, it will be made clear.
It has to be settled.
The property was the original lessee was there.
Yes.
Lessee, during his lifetime, we were in a portion of the property. The lessee did not renew the lease. Lessee left that place. They forcefully entered that premises.
No. It's not correct. We are in possession since 1967. They are also the party.
Government has sent, and we are in possession of the rest, some portion, and my vendor's great granddaughter is in possession of certain property.
My lord, may kindly see. My lord, I may be.
Eviction proceeding is there also.
Against them, not
My lord, eviction proceeding cannot stay, cannot continue because of the OPPU Act. Annexure 5
because they are in unauthorized occupation.
Yes.
They claim that we have got subsisting title, which is adverse to the title claimed by the opposite party.
Eviction proceeding is there against them, staring at them. Eviction order.
No, my lord. OPLA proceeding is not maintainable.
Not maintainable.
The OPPU Act to be maintainable. That after, well, the government land, this is, my lord, kindly see Annexure 1. What is it, my lord? Annexure 1 at page number 17.
But what I find interesting, Mr. Hota, is,
my lord,
in your petition, you don't impede them. In their petition, they don't impede you.
Appeal proceeding is not maintainable, my lord. Doesn't matter. Because we are a party, my lord. We are national party to be maintainable. We are having appeal since 1960 Johnson days. Government and this is, my lord, kindly see Annex 1. The possession, my lord. And we have applied for the lease, but it is number 17. Considered, it was rejected by the
What I find
RDC.
interesting, Mr. Mehta, is in your petition, you don't impede them. In their petition, they don't impede
Appeal
you.
proceeding is not maintainable. Doesn't matter. Because we are a party, my lord. We are national party. We are having appeal since 1960 Johnson days. Government and this is, my lord, kindly see Annex 1. The possession, my lord.
The original
And we have applied
says
for the lease, but it is number 17. Considered, it was rejected by the
What I find
RDC.
interesting, Mr. Mehta, is
My lord.
in your petition, you don't impede them. In their petition, they don't impede you.
Proceeding is not maintainable. Doesn't matter. Because we are a party. We are national party. We are having appeal since 1960 Johnson days. Government and this is, my lord, kindly see Annex 1. The possession, my lord. And we have applied for the lease, but it is number 17. Considered, it was rejected by the
What I find interesting,
RDC.
Mr. Mehta, is in your petition, you don't impede them. In their petition, they don't impede you.
Proceeding is not maintainable. Doesn't matter. Because we are a party. We are national party. We are having appeal since 1960 Johnson days. Government and this is, my lord, kindly see Annex 1. The possession, my lord. And we have applied for the lease, but it is number 17. Considered, it was rejected by the
What I find interesting,
RDC.
Mr. Mehta, is in your petition, you don't impede them. In their petition, they don't impede you.
Proceeding is not maintainable.
123 may please. Limited grievance policy that money. Not been done. 123 may please. First time limited grievance policy that money.
How can it be, sir, after 7, 8
Not issuing notice. 123 may please. First time limited grievance policy that money.
How can it be, sir, after 7, 8
Not issuing notice. 123 may please. First time limited grievance policy that money.
How can it be, sir, after 7, 8
Not issuing notice. 123 may please. First time limited grievance policy that money.
How can it be, sir, after 7, 8
Not issuing notice. 123 may please. First time limited grievance policy that money.
How can it be, sir, after 7, 8
Not issuing notice. 123 may please.
I replied to
Limited
it and
grievance
then
policy that
respected
money.
and it was erased from our I replied to it and then respected and it was erased from our I replied to it and then respected and it was erased from our I replied to it and then respected and it was erased from our I replied to it and then respected and it was erased from our
stamped by the stamped by stamped by stamped by stamped by stamped by stamped
I